If you'll join me as we traditionally do, we'll do start the meeting with the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I'm going now to read the notice of appeal process. Please listen up carefully. This is an appeal process of any decisions from the Metropolitan Transportation Licensing Commission. Pursuant to the provisions of Section 2.68.030 of the Metropolitan Code of Laws, notice is hereby given that if you are not satisfied with a decision made by the Metropolitan Transportation Licensing Commission, you may appeal the decision by petitioning for a writ of certiorari with the Davidson County Chancery or Circuit Court. Your appeal must be filed within 60 days of the date of the entry of the Metropolitan Transportation Licensing Commission's decision. We advise that you seek your own independent legal advice to ensure that your appeal is filed in a timely manner and that all procedural requirements have been met. All right. Mr. Rooker, I understand we have a new member of the commission today.
Yes, Mr. Chair, we do. We have a new member, and we also have a returning member. So I will give you the mic to introduce.
All right, Mr. Sloan, Alan Sloan, you've been I think you've been appointed by the mayor for a 2-year term. Is that correct?
That is correct, sir.
Would you tell us a little bit about yourself? Introduce yourself to the other commissioners and to the public, please.
Well, hello. As he stated, my name is Alan Sloan. I've been a resident of Nashville off and on, but most recently since 2009. I'm a lawyer by training, but currently work for a small subcontracting company as an estimator. Do a little law in my off hours. I actually was introduced to the Transportation Licensing Commission by a mentor about 15 years ago. So when Miss Olivia Hill asked if I had any interest in serving on this fine board, I said, actually I do, and I'm even familiar with what they do. So I was very honored to be appointed by the mayor, and I look forward to working with each and every one of you.
Well, welcome, Commissioner Sloan, and we look forward to working with you. And our returning member of the commission, Commissioner Carr. Got anything new that you want to introduce us to since the last time we saw you?
No, just trying to catch up, see what's been going on in the sandbox since I've been gone.
Well, I'm sure you read the minutes that have been provided to all the commissioners, and you should be the first one to make a motion on that. So.
Okay,
all right. As we always do, each meeting we have a opportunity for the public to speak, and I have 3 people that have indicated a request to speak today. I want to remind you that we limit the comments to 2 minutes, and they must be about something that is on the agenda, on the commission's agenda today. The first one is Michael Winters. I almost would say returning Mr. Michael Winters.
Sure, I talk more than you really want me to.
Good afternoon. Well, I'm going to give you 2 minutes. But good afternoon, Mr. Winters.
There we go. Well, in reference to Michael Winters, Nashville Tractor, crews in Nashville, operates sightseeing and the party style ETV stuff. On the agenda, where we have a proposed rule change that I don't have all the context on yet, and I think we're probably going to get into that as this meeting goes. My fear, and very candidly, I'll be as blunt as I can, my fear is this is very potentially another rule change that has closed door meetings that have happened already prior to this meeting that have set some things in place that potentially benefit one company in particular, and maybe a couple others, and maybe even a pay-to-play scenario that we'll figure out as we go along. I have a letter from my attorney I will pass out here shortly, spelling out some of the things we might want to consider as we move forward. I know you guys probably get tired of me talking about conspiracy theories and how things benefit other parties. But as an example, I also have a packet for you to review at your pleasure. Approximately a year ago, Old Town Trolley has been operating at WeGo bus stops, which are state funded and not allowed. That route was approved by NDOT. So NDOT reviewed the route and approved the route for them to use bus stops, zones that are not loading and loading zones. And I think this is very candidly another attempt to carve a special rule category that very candidly might apply to them, and maybe Gray Line, I'm not quite sure. So I have a packet here for your review later to look at the routes that were approved that use WeGo bus stops, which I've talked to WeGo executives, that's not allowed, as well as state that says that's not allowed. So I have a continuing problem with rules being decided that very candidly I think come back from backdoor environments where they're trying to carve out certain subsections of the ETV world as a bias to other players involved, is the gist of my 2-minute comment. I think I kept it in line there. But the last note I will put in real quick is 5/9/24 at there was a meeting May 9th, 24th. At the 45-minute mark, I brought up WeGo bus stops are being used. Attorney for TLC said they look into it. That was a year ago. Nothing's come out of it. So I brought a packet today to highlight it again. That's been occurring for over a year, just like the 4-6 thing did that took 2 years to actually resolve. On 7/18/24, on the video from 1.50 to 1.52, NDOT said they will review all routes, stops, and anything related to said routes to make sure they comply with city and state statutes or whatever applicable. If that's the case, how are they been using WeGo stations for dozens of times a day, every day? For example, Rosa Parks, right there in front of the farmer's market. My point here is I'm not complaining about Old Town. I know it always seems like I'm out to get them. It's not. It's about making subsections of rules, which I think we're going to talk about today, that benefit a party or maybe parties and not the industry, I guess is my concern here as we go into this rulemaking. That being said, for reference sake, I do have the route for anybody who wants to review it, as well as a letter from my attorney referencing how we might want to go into this cautiously for your review if you want. Thank you.
Grant Rosenblatt own a company. It's actually now Honky Tonk Party Ventures, but it's Honky Tonk Party Express in the past. Is this on? I can't hear if you can. Yeah. What's up? Hang on. Let me re-push it. Yeah. Okay. All right. And Mr. Rooker also has it's a letter from just our attorney. Again, the reason that I put this letter out forward is not to cause.
What are you speaking on?
Oh, I'm speaking on the rule, section 805F.
Okay.
And we just have a letter from our attorney. We learned earlier this week that there was going to be a rule change that either was not discussed, previously told, or anything like that. So considering that myself personally don't know how the rules exactly work, if things can get voted on in the meeting, or if they get discussed 1, 2, or 3 times like they do at the city council, I just want to go ahead and put a letter forward just from some topics of conversation. So yes, we were just reaching out to the Metropolitan Transportation and Licensing Commission for rule change section 805F. It just appears that it's unclear and what the purpose of such hearing is, and no such purpose is really clearly articulated in the agenda, which that is true. And I won't go through all the details on it, and you will get the packet from Mr. Rooker if you don't have it already. But we had about 7 concerns regarding this. One is the purpose of the traffic study to determine where the ETVs can operate during 4 to 6? And if so, would those traffic studies be completed during that period of time? Also, number 2, how is travels at the speed of limit or maintained speed to keep up with the flow of traffic defined? Does that mean 25% of the time? Does it mean 75% of the time? Is it tied to certain days of the week? What roadways? 3, on what roads must traffic studies be conducted? 4, how much experience is needed for an engineer to qualify and to study for it? Example, is it a 1 year, is it 1 study, 2 year, or 2 study, 3 study, 4 study? 5, can each ETV operator propose a different methodology for the study that they're going to potentially will be voting on or talking about? And then also 6, has any other operators already completed a study that has been discussed previously that would be presented today as well too? And if so, 7, it's just, if that is the case and these things have been previously talked about, not in a public forum, and potentially could get voted on today. Is that going back into the backdoor talking, the special deals, which we've discussed here previously before. So really not knowing what's going on, the agenda being very unclear and not having any previous conversation on the rule change or what's going on. This is just our letter from our attorney, just questioning before we make any changes, what, when, who, what, and why.
Who's the attorney?
Sims Funk.
Okay. Did you bring a copy for everybody?
I did. They're over there.
Okay.
Thank you.
All right, then, Jeanette Barker asked to speak.
Good afternoon, members of the commission and NDOT.
Can you give us just a moment here while he's handing out these letters, okay?
Yes. Yes, I'm Jeanette Barker. I am here representing the Nashville Downtown Partnership. Yeah.
And what are you speaking on?
I have a comment today on the proposed change to Rule 805F.
Okay.
And representing the Nashville Downtown Partnership, we will support policies that build a better downtown, and will also speak against policies that we believe would negatively impact how downtown works best for all of us together. And we stand against this rule change. We did speak in August also against a proposed amendment to Rule 702, which was being amended to allow approved routes for pedal carriages to operate during rush hour. And we still believe that any slow-moving vehicle operating downtown during this time adds an undue burden to the thousands of Nashvillians and visitors who are trying to move in, out, and through downtown. The underlying philosophy here, which is to allow permitted routes when a study can prove that a vehicle can keep up with the flow of traffic, seems to us objectively flawed. During rush hour in practically any center city, keeping up with the flow of traffic is commonly a moot point, as congestion may often mean that even pedestrians could probably meet that threshold. If the core's flow of traffic from 4 to 6 is what you mean in this language, and what that speed is, we think that this is a bar that many could meet, rendering the amendment merely a loophole at worst. If that's not your intended definition for flow of traffic, then I think that this needs to be clarified. Another important clarification that is needed in this language before a vote can be taken is whether approvals are being granted for the area outside the previously stated no-go zone, which, as a reminder, is from KBB up to Union and 1st to 8th, or is any approval that could be granted inclusive of that previously stated no-go zone. Please keep in mind that a primary issue with these rules, which speak to the rush hour allowances, what they do is they push slow-moving vehicles outside the no-go zone, but allow for case-by-case operations outside of it during rush hour, and that there are fewer streets outside that zone, and that what this does is pushes congestion into a yet smaller box, which compounds congestion specifically for all the vehicles trying to leave through our limited arteries outside of the downtown core. And thank you for your consideration.
Thank you. Okay, next we're up on the, have the commissioners had an opportunity to review the minutes from our previous meeting? Mr. Clark?
Oh, sorry, I'm breathing. I did when I got here, yes.
No, have the commissioners all had an opportunity to review the minutes from the previous meeting? Okay. I'm just picking on Mr. Clark a little bit here today. I've missed him. And if so, is there a motion for approval of the minutes?
A motion to approve.
Is there a second?
Second.
All those in favor say aye.
Aye.
Any opposed? The motion carries. Mr. Rooker, we have a number of consent items on the list today.
Yes,
Could you help
sir.
us with that, please?
Yes, sir, Mr. Chair. We have, first on the consent agenda, other passenger vehicles for hire. We have 15 new companies that have applied this month. I know it seems a little high, but we're not sure why. We usually have 4 to 5, but this month we had 15 new companies. We currently have 496 companies and approximately 750 vehicles. All these companies' applications are in order, and staff would recommend approval. Then the names can be read into the motion.
Again, as when I left, are most of these single unit,
Yes, sir.
one-off, I've got a SUV?
Yes, sir. That's basically what they are, the big SUVs.
As I understand, a lot of them are black Ubers.
Yes, sir. And they could be Lyft now also. Lyft is now requiring them to register with us as well.
All lifts or just the high end?
Just the high end, the SUV lifts.
Does anybody have any questions of Mr. Rooker?
And all these have been reviewed?
Yes, sir. All applications have been reviewed and they are in order.
I would like to make a motion to approve if all are in order.
I'll second.
All right, yep.
Thank you. Do book the black. The driver hands me his card and says, next time you need a ride, call me, to try to get around, I'm assuming, the dispatch fees from Uber. Is that legal?
It's legal with us. I don't
Right,
think they're
they've-
violating any law.
Yeah,
They may
okay.
be violating their agreement with Uber or Lyft.
But relative to being legal, they've been, I guess they've, to the extent I've called that car through an app, a ride-hail app. I've picked it up, I've had a successful journey, it's been great. He hands me, or she hands me a card, it is legal.
Yes, sir. It
Yeah,
is-
because they're
it is
licensed to
legal.
do business. Yeah,
Yeah.
perfect.
Yeah, we're
I have an
permitting the
Uber driver
company or
like
the
that.
person.
Do you what?
I have one like that I know him personally,
Yeah.
but you have to just think and assess, it doesn't change their insurance.
Yeah,
They're still insured while they're driving you. Their vehicle is still a licensed vehicle.
Yeah.
Whether, like you said, I think the issue would be more if they're breaking an agreement with Uber or Lyft.
Right.
But, yeah.
thank you for indulging.
Yeah, no,
Personal question there.
I don't know why they never offer me a card, but maybe I don't tip as well as some other commissioners.
They don't know the tip until well after the fact, you know?
There's been a motion, there's been a second, and Mr. Carr, I hate to put the burden on you, but I'm afraid you're
I'm
gonna
gonna
have to
read it.
name each one of these
I'm gonna
companies
read it.
in there, please.
I'd like to make a motion to approve, and excuse me if I'm not saying this right, Zohisa LLC, Miami Display LLC, Freedom Limo Service, Southern Transportation Solutions LLC, MPS Transportation LLC, High Sky Luxury Limousine Service LLC, again, excuse me, but Godino Transportation, Black Horse LLC, Luxury Forever LLC, Magnolia Car Service LLC, DJ Smooth Entertainment, DBA Grand Rides, Legacy Rides, Nathan Limo, Music City Sedan, MGM Elite LLC.
And I believe there was a second to the motion to
Yes.
begin with?
Second, again.
All right. All those in favor of the motion say aye.
Aye.
Any opposed? Motion carries. Mr. Rooker, next on our agenda for consent items is the General Wrecker and Towing Services new company application.
Yes, Mr. Chair, we had a new company apply to just be a general wrecker in Davidson County, Tow Auto Park LLC. We currently have 39 companies and approximately 250 wreckers that are registered with us in Davidson County. They're gonna be a general wrecker, so they're not doing any non-consent towing at this time. They have to be a general wrecker company for a year before they can apply to be a non-consent wrecker company. All of their paperwork is in check and in order, and staff recommends approval.
And I know you had educated me or reminded me that when we do have a public hearing, it's about the non-consent towing, correct?
Yes, sir, that is correct. We have to have a public hearing for zones and non-consent tows,
But not for the general record?
not for general wrecker companies, correct.
Okay. Does anybody else have any questions or concerns?
So are we in need of more non-consent towing?
I'm just assuming with them applying and starting a business here that there's a need for more records. Yes, sir.
I know we have a general need, just looking at the interstates. I know there's a general need for more records out there. It's just, with the non-consent towing, I know there's a lot more leeway given as far as, picking up vehicles and towing vehicles.
Yes, sir.
So I don't know. Again, tell me what the requirements, how long do they have to be?
They have to be a general record company for a year before they can
With no
apply to be a
complaints.
non-consent record company. Yes, sir.
And that's with no complaints?
That's with no complaints or no issues. Yes, sir.
But towing auto is just applying for the general record service, not
Yeah, they're just applying to be a general record company. After operating for a year with no problems, if they wanted to apply to be non-consent, then they could do that. Most non-consent tows are done from private property.
This is a little bad of a read on that there.
Yes, sir. It doesn't look too good. That's okay.
Any other questions? All right, and Commissioner Sloan, for your edification, this is one of our historical areas that we have regulated, which was the towing business. Originally, it was cabs, towing, and horse-drawn carriages, and you'll learn sooner than later, probably sooner, that we have a lot of other areas we're covering now, or regulating now, so.
Yes, sir.
All right, is there a motion about towing auto parks application?
If everything is in order, I motion to approve.
Second.
All those in favor say aye.
Aye.
Any opposed? All right, the motion carries for Towing Auto Park LLC. Their application is approved. Next is Pedal Carriage Company request to change address. Well, Pedal Carriage comes up yet.
Yes, sir. Music City Crawler is making a request and wanting your approval for moving from 400 Davidson Street to 801 Representative John Lewis Way. Anytime that there's a change on the original application, it has to come before the commission to approve. Staff has looked at this. All of the paperwork is in order, and we recommend approval.
I'll move that we approve the address change.
I'll second it. All those in favor say aye.
Aye.
Any opposed? Motion carries. All right, going to what's now my second page of the agenda today, we have the entertainment transportation. Mr. Rooker, I think you had a reminder you wanted to publicly announce today.
Yes, sir, we do. We have a reminder to all the companies that the deadline for the ET application is Monday, March the 3rd, 2025 at noon. I'm sorry, yeah, 2025 at noon. The ET driver permits expire March 31st of 2025. We would like to request that you don't wait till the last minute to come file those. We would, if you can do it early, do it early. If we have a bunch of companies coming in on March the 3rd, and they got to be in by 12 o'clock, you're going to have to wait for a while. So we request that the companies get their paperwork in as soon as they possibly can.
And then, Mr. Rooker, there was another matter that I'd like to take out of order. It was about deferring the matter to the next meeting. Can you help me with that, please?
Yes, sir. The attorneys for B&T Transportation and Turner Crisp, which is Rowdy Bus, they were unable to be here, so they called and asked that we defer this one meeting. Traditionally, the commission has, allowed a continuance for a one-time continuance, so we recommend that this move to March's agenda.
Is that the third matter that's underneath entertainment transportation?
Yes, sir. It's the third on the agenda.
So the lawyers have asked for a continuance of 1 month. Traditionally, we've granted parties at least one extension.
Yes, sir.
All right, and you're recommending it?
Recommending that we defer.
Okay.
Mr. Rooker, may I ask, it's my understanding that that's a pretty robust docket we've got going next month. Is that correct?
No, sir.
Okay, all right, it must have.
April will
okay.
be.
All right, that's why I was just saying, maybe we need to push it 2 months as opposed to the one,
Yeah,
but that'll work.
April will be a little busy.
All right, thank you.
All right, is there a motion about deferring we do have to vote on this, so is there a motion for deferring BT and Transportation's matter to the March meeting?
I make a motion to defer.
Is there a second?
Second.
All those in favor say aye.
Aye.
Any opposed? All right, the matter's been deferred to the March meeting. Now, next up is the public hearing regarding the TLC Rules and Procedures, Section 805F. And we've had 3 people speak about that already today. Mr. Rookie, you want to kind of introduce us into this agenda item, please?
I'm going to allow the Director of NDOT to address this issue.
Well, welcome, Ms. Alicorn. We've missed you the last few meetings.
Well, thank you. The team's doing such a great job, I don't need to be here. So I'm appreciative of that, but I felt this was something I need to bring back and kind of introduce as to why we're bringing this back before the commission again. If you remember this whole ruling, when it came to the no one's allowed in the downtown core between the hours of 4 and 6 was part of Connect Downtown. So I just want to give a little bit of background history as to why and how we got here and and then why we're coming back with the rule change. So, at the time that we actually were establishing regulations for the ETV and sightseeing, we were also undergoing a study called Connect Downtown. And Connect Downtown was looking at how we can move people more efficiently through the downtown. It was about balancing everything. So, we have a very strong entertainment district. We have a lot of new residents that moved into downtown. Plus, we have Class A office buildings. And we also have, ETV sightseeing because of the tourism and just the attraction of Nashville and the history that comes with it. So trying to get all that balanced is really important so we can make sure that we're maintaining it at and we're not losing business in any of category of use downtown. So Connect Downtown was looking at all of the things that they needed to do. At the time, we were undergoing that, but one of the things that did get highlighted was that we had an issue between 4 and 6 of being able to empty a lot of the office buildings, a lot of the some of the visitors that were coming down in that specific time. We weren't able to get them out. And the other part of that was also looking at transit. And we had discovered that it was taking our transit operation, because right now we only have one central station and it happens to be downtown. We are looking to grow that business, and part of Choose How You Move will give us those opportunities. But at the moment, that's our main station, and that's where all the buses come in and do their transfers and then go back out. And it was taking them 13 minutes to move 1 block. So we had come in asking for a regulation that would prohibit folks from actually being able to operate the ETVs and also the sightseeing vehicles at that time. When we did the study, we referred to it as slow-moving vehicles, because we can't go in and disseminate the difference between ETV, pedal carriage. Did I say it right? Mm-hmm. Pedal carriage. I always mess that one up, and I don't want to do that. And then also with the sightseeing, and also with the horse and buggies, because it takes all of that into consideration. And what we found is that during the hours of 4 and 6, when there is a lot more congestion because we're trying to get people out, residents are coming in, we got tourism going on, a lot more folks are in the downtown core at that time for the entertainment district, it was breaking the system that nobody was moving. We were actually creating parking lots. So we made a request that we consider that we actually put a restriction that does not allow anyone to operate that's a slow-moving vehicle, which I just defined as ETV, sightseeing, pedal carriages, and horse and buggy, between the hours of 4 and 6.
That's under 20 miles an hour.
Well, it was under 20 miles an hour, thank you. And so, and y'all granted that, and we're extremely appreciative of that. Well, a year ago, actually last year, we came back and shared this final study, and we also had that codified by council that gave us permission to move forward with the implementation of Connect Downtown. Connect Downtown is a 10-year implementation plan. I am challenging my staff to get it done in 7. So I want to give you a little bit of an update of where we are with it, because we're almost a year into Connect Downtown and the implementation plan. So one of the things that we have done already, excuse me, is we've actually, and I hope y'all have noticed, we've actually built out corrals for the scooters as well as for bicycles. We're also continuing to work with the scooter companies to make sure that they have put incentives in place that would encourage people to go back. And actually, we had a meeting with them this morning and learned that 30% of their users are actually using it. So we're seeing some positives come out of it. Our goal is to get it to at least 70% of them using it. But if we don't see that happening, we'll actually come back and look at putting in some things that would actually be punitive if they do not do it so that we can get the behavior change we want. We also discussed about appropriate times for pickup, but the whole idea was to get the scooters off the street, off the sidewalk, out of the way so that we were not pushing people into the street. We had the sidewalks available and clear for safety reasons and also for the number of tourists that we actually get in the downtown core at any given time. So that's one thing out of Connect Downtown that we've put together. The other thing we've actually we're doing with Connect Downtown is we're getting ready to, we are working on a signal timing improvement. So 2 things with the signals I just kind of want to share with y'all. One of them is we are actually working to take all the signals and put them into real-time adaptive signalization. Programming, adaptive signalization. And what that means is cameras will go up, we'll improve all the signals, we'll have the ability to manage it and run software so it'll run on a queuing. So based on the number of how many cars are in the queue, it'll change the light, it'll change the next light so we can get more green and get more flow out, especially in peak time. That is currently under design. And then we're hoping that this fall, we'll actually start moving into construction. It'll take us about 9 to 12 months to actually redo the construction because we have to rebuild all of the actual intersections and we have to put in fiber and a whole bunch of stuff. So it's not as easy as just throwing up a bar and some lights. It's a little bit more intense than that. So that is currently underway. In the interim, what we've done is we've actually done a study of how we can actually look at improving the signal timing in the short term to help us have more efficient flows out. So we've just concluded that study. We're now diving into it, and we're hoping to actually have that in place and implemented by the end of April. And that, I think, will make a big difference, especially as we go into tourist season. The other thing I want to share with you is we are actually going to be piloting a project for loading and unloading. This is mainly where, I skipped one. Don't let me forget TPAC. We will be piloting. This will be on Broadway and as well as 3rd and 4th south of Broadway to Demonbreun. What we're looking at there is one of the things that Connect Downtown showed is that we do not have enough unloading and loading zone. And so we're going to be expanding on 3rd and 4th, the loading and unloading zone. And as Broadway, we're actually going to be using technology to help us make sure that we hold everyone accountable to the time frames that they can be in there. Instead, and also it will act as a deterrent for someone who shouldn't be in there not to use it, which is typically our biggest problem right now. If somebody's illegally parked in the unloading zone and then the trucks just stop in the middle of the street, which is part of our traffic congestion. So we've been working very closely with many different folks in the industry, from property owners to delivery trucks to the tour buses, having this conversation about how all that will work in the pilot. And we're looking to get that actually up and running this summer. So that's a great thing. We've already started some pretty strong enforcement of the unloading and loading zone, especially for those folks that shouldn't be in it. And this leads us to, I want to share with you a pilot that we currently have going on that will actually be completing, where we've been working with the rideshare companies. So the unloading zone is meant to work in the morning and the early part of the morning for unloading of all goods and services, especially for the entertainment district. In the afternoon, it's meant to flip to what we're calling a share zone, and that becomes where cabs and rideshare can actually pick up and drop off. And what it'll do is it'll send the customer to that place, and that's where they'll pick up the car. It'll also bring the rideshare to that place. So we are unfortunately getting away from front door delivery, but the hotels, if they have a porta share, they'll be able to deliver front door there. But other than that, it'll take them to a rideshare drop-off zone and pick them up from a rideshare drop-off zone. And we're actually piloting that right now with TPAC. They have been great. We've been piloting it for their different events that they have, their shows. We've been doing that for a month. A lot of great lessons learned, and then we've had opportunities to tweak and make it better. So with all of this going on and looking at what the traffic congestion has been, we went back, and so as I shared with you, part of Connect Downtown is as we make improvements, we're going to annually do a review. And so one of the things, knowing that this has been a question that's been asked a lot of time, is if we want to operate during the hours of 4 or 6, what will it take to make that happen? And so staff has sat down and kind of said, well, there's a few things we can do if we're going to allow operations to 4-6, and that's where the ruling came from. We wanted to make sure that they would be flowing with the traffic, not creating congestion. We wanted to make sure that they met all of those objectives, and that it also fell within the objectives that we asked y'all to regulate for us through Connect Downtown. So that is where this ruling is coming from. Again, we're gonna come back to y'all as we move forward with Connect Downtown, as we make these improvements, where we feel like we can continue to allow the adjustment and regulations and business practices. And it's not only just the TLC that oversees some rules, this also applies to other things we have going on through Connect Downtown that may not be under your jurisdiction, that we're adjusting as we go, because Connect Downtown is looking at how we can all better use the curb and maintain a great traffic flow. And that part of that is also transit, looking at alternatives of where we can put stations, so they don't have to use Central Station to transfer. So everything's going in this conversation, and Choose How You Move is a really key player in this, and it's allowing us to now really think different. So we're super excited about, as we move forward, about really creating a more dynamic downtown that will work for everyone. So thank you for that opportunity.
For the benefit of the public, I realize we all have received a notice of what the additional proposed language would be to Rule 805, but would you kind of summarize what the addendum to the rule would be?
Yes. Hold on 1 second. I'm actually, TV's going to put it up.
Okay.
So then that way everybody can see it.
And that would be the lower paragraph that's
Correct.
in red. Okay.
So, an entertainment transportation vehicle operator seeking to operate during prohibited hours 4 to 6, Monday through Friday, must first obtain a traffic study performed by an engineer who is licensed in the state of Tennessee. And that is a standard practice, just to let y'all know, that we do right now. We actually, when a new development is coming in, we're actually requiring a traffic study be done to understand the impacts that they will have to the traffic. So they will have to meet with staff. A methodology meeting will be done, and the methodology meeting will include such as the impacts that their particular vehicle can have to the traffic, and then how and what will be any mitigation for consideration, or how they'll operate to make sure that they're not impacting. So currently, right now, we know during peak time, the average speed limit is around 20 miles per hour. So we would be looking for a minimum of 20 miles per hour. And then that way we would do it. But we're constantly checking that all the time, just to let you know. But at this moment, it happens to be 20 miles per hour. So just to continue with it, the engineer or engineering firm and the methodology to be used in the traffic study must be pre-approved by the NDOT's chief engineer. Again, this is a standard practice we do right now. It's kind of following the same program we did with allowing for those fixed routes to happen between 4 and 6 on other roads. That is actually, we study the routes, we look at them, the team looks at turn radiuses, they take a look at everything. So our chief engineer, who also has traffic under his belt, will be looking at this, and of course, we want Ricky to take a look at it as well. Thank you, this makes it easier for me. I don't have to turn around and talk away from the mic. And all of this is gonna be a conversation we have together prior to, them moving forward with the study. And it does need to be, again, a licensed engineer. So that'll be really important as part of the study. The traffic study must demonstrate that the relevant entertainment transportation vehicle travels at the speed limit and maintains speed to keep up with the flow of traffic. That'll be a really important part of the study. With passengers on board during normal operations for which is presently permitted. If the traffic study does not demonstrate that relevant entertainment vehicle travels at the speed or maintains speed to keep up with the flow of traffic, then the operator's request to operate during the prohibited hours will be denied. So it's really about making sure that they are not hindering the traffic flow, they're staying up with the traffic flow, and that we're not seeing any congestion being created. So again, we'll constantly be reviewing everything in the regulations and bringing these back to y'all for consideration and change as we are continuing to make improvements with Connect Downtown.
So the first part that's in black, that remains in force. And this red part is to be added as an addendum.
Correct.
All right, so the presumption is that ETVs will not travel from 4 to 6 in the downtown corridor unless they can meet the second paragraph.
Correct.
Since you are the have been designated the spokesperson, I have a couple observations or questions. And one is, when we were first looking at this, Rule 805, or looking at the traffic downtown and trying to alleviate the congestion, one of the things we looked at was removing non-essential vehicles from downtown. And at that time, sightseeing ETVs were considered, we took the position that if you trying to minimize the number of vehicles that are on the roads downtown, and ETVs and sightseeing vehicles were considered ones that we could live without from 4 to 6. How do we rectify that initial reasoning or rationale with the addendum that's being added? or
So
being
it was
suggested?
based, excuse me, Mr. Chair, so it was based on the data that we actually presented to the commission. And that data was, if you remember, we actually, our engineering partner in that and consultant was KCI, and they came in, and they actually came in twice and did a presentation. And what they did is a simulation using the data we already had of what was occurring in downtown. And they ran it for more than a 24-hour period. And it looked at the different times. So right now, operation doesn't start till 9 o'clock. So that gets them out of the peak morning time issues of getting people in. So there's no conflict there, but there remained a conflict at 4 or 6. So when KCI did their study, it was based on slow-moving vehicles. It wasn't necessary about removing vehicles to reduce congestion. It was about vehicles that were moving slow, that were creating more congestion. And that's what we really were focused on, because that we can simulate and run. And again, we called it slow-moving vehicles, but we could not determine whether it was an ETV, a sightseeing, pedal carriage, or a horse and buggy that would be operating. So it was, they all got slumped together. And again, as we continue to work through and implement Connect Downtown, we're looking at ways we can better define or refine some of the regulations that we asked, because in the beginning we were in the middle of the study and we knew we had this issue. We just didn't know all of the causes, and now we're honing in a lot closer, taking the studies to the next step, that we're understanding how traffic is flowing enough that we now can do signal timing improvements. We also are moving all of the rideshare out, and we're also doing the unloading zones. We're filling and we're expanding the implementation plan. We've looked at this as well, and this is something I had committed to when we were first started Connect Downtown over 2.5 years ago. Oh my gosh, I've been talking about it that long. We would come back on a regular basis and give you updates and share with you, and also from time to time offer some changes in the regulation, because we felt much more comfortable. So we feel comfortable that if they can show through a traffic impact study, which is a standard practice for our department, that they can move with the flow of traffic and they're not going to create congestion because they are a slow-moving vehicle, we were comfortable at this point to allow them to be back in the downtown core.
Mr. Winters brought up a concern that it might only apply to some ETVs or some sightseeing. This is open to anybody that can meet the requirements of that second paragraph.
Yes, sir.
All right. Well, I've asked a lot of questions, but other commissioners.
I would be curious, thinking about this regulation, I think anybody could produce a traffic study that shows their bus, as an example, can flow with the speed of traffic. We know that some buses don't, because it's not safe for the people that are standing when they're making a turn to be going 30 miles an hour, 25 miles an hour. When we were sitting in my office a few years ago, you said, hey, our buses can go the speed of traffic. But then you said, hey, we don't tell them to because it wouldn't be safe for the people that are standing. That's an example. You could produce a traffic study.
I've asked the council how fast he wants to go downtown. Vehicles manufactured can go 60 miles an hour.
You totally could, right? So anybody could produce a traffic study that said the vehicle could go. Yours can. They can go. Your passengers are seated. Maybe they don't have a seatbelt on necessarily, I don't think, do they? But they can go fast. One of the things that this doesn't really address in my mind is acceleration and how you flow through a stop sign or a traffic signal. So I think about, as an example, my pathway home some days, southbound on First Avenue at Korean Veterans. The signal's timed for about 6 cars to make a left, and it backs down First down to Mumbrian for about 4 blocks if you look down with a drone or stand on our roof and look down. If you put a bus in front of it that can't accelerate up the hill, that flow through goes from 8 cars to 1 or none, right? Maybe just the bus. So I'm just curious, how you guys think about that, particularly allowing, even recommending to us to allow slow-moving vehicles, because you could open this up to maybe not the horse and buggy, but the other guys could probably show a traffic study that shows, yeah, we can go the speed. They may not ask them to. They physically may not because of just acceleration. A fully loaded bus with a lot of passengers starts really slow. And if you hit every single signal because it's timed for a car, you're really going to muck up, in my non-engineering language, you're going to muck up the speed of traffic. And I didn't see that the traffic studies that were emailed to us even began to contemplate that. So I would hope that if you're going to, if NDOT is going to recommend to this commission allowing vehicles to come back into the heart of the core at peak times, that there is some consideration on more than just the flow. Because if it's all green lights and it's all running, everybody can go 20 miles an hour.
Right, and so that's why, well, I'm not an expert on traffic studies, so that's why in this language, they have to perform it when they have passengers on board, so that that's taken into consideration. And also in here, it does say that they will meet and have a mythology meeting that will discuss all of that and how they're going to interpret it and what data they're going to collect and provide back to us for us to review and consider if they meet the intent of being able to flow with traffic. And so right now, doing a study now would show one thing, but when we fix the signals, it could show something else. So all of that is taken in consideration. I'm not the traffic engineer, so I would muck it up as the words you use. So that's why we were very. That's why we put in here that it would be going and working through the chief engineer because that's their expertise.
And do you think it would be maybe more appropriate to bring this to us after the traffic signals have been installed in October?
I don't think it'll make a difference. It'll make a difference in the mythology. So again, a sit-down bus, if someone's going to bring us a traffic study, for a sightseeing where they're sitting down, because some sightseeing vehicles that operate today actually have people standing. They're not supposed to, but they do, and we've seen it and witnessed it. They would have to demonstrate that they can move at the flow of traffic, even if someone is standing up on the bus, even though they're considered sightseeing. But we look at that. That is taken into consideration. Again, I'm not the traffic engineer, so I don't want to muck it up, but that's why we require mythology meetings, so all of that can be discussed. It's actually, minutes are taken, it's all lined out. They get it, so their engineer knows exactly what to do, and then we have it to make sure that we're checking that. And it also makes it fair that they're not going back and forth, because what we don't want to do is have them come in and then, oh, we forgot this, or oh, we don't want to do that. This is what we defined as the methodology to your study. This is what you have to produce, and the study needs to meet that.
One of the questions that I had about this was kind of twofold. One, the lack of standards, as is mentioned in the letters that were provided through the individuals who made public comment. Whether I'm in support of this or not, I think that is an excellent point, that we don't necessarily know what is supposed to be the parameters of this study. We know that it's supposed to be approved by the chief engineer, and we know that it has some methodology to it that has to be determined, but without having that delineated, it invites any amount of challenges from anybody who may feel like they've been aggrieved by this. And I think that one of the purposes of making these regulations is to make them as clear and concise as possible, where everybody understands they're on the same footing. So regardless whether I'm in favor of this or not, I think that having those standards lined out before anything is approved would be just in the better interest of everybody in good governance. My second issue that I'm seeing with it is that, as everybody stated, anybody can successfully execute something once while being observed in a situation. However, 6 months, a year down the road, if we have a truck of complaints that are coming from drivers who are saying these people aren't in fact meeting the flow of traffic, because even if the study was done as well as possibly could be done, we may still have people that are not meeting those requirements and are in effect defeating what the area was supposed to be.
And that would be, so to answer one, don't disagree, that's why we require methodology and everything's laid out in the methodology. And it does vary based on many different things, but that's one of the upfront requirements is that methodology, and that's a standard practice in the traffic engineering world. Even it's a practice we use today when we are doing new developments. We will sit down with the developer and with their engineer that they choose, talk about the development we want to do and the traffic impacts, and have them put together a study based on those impacts.
And I can appreciate what you're
But-
saying there.
And that is kind of laid out already in what we call our multimodal traffic analysis. It's already kind of laid out, so we're following that same program.
Okay, so that is
It is
somewhere.
lined out, but I do agree it could be better defined, so I actually made a note so I could do that.
Thanks.
And then as far as if at any time that they're failing to meet the requirement of this, we would bring that back up for y'all with the recommendation of revoking the permit.
Okay.
So there is a way in actually to move that forward. So if they're not meeting it and we're getting a ton of complaints, we'd bring it back before this commission to consider, or we can, which is what we would have to do anyway. There is that, where we're to bring complaints and concerns back before this commission for consideration. We'd follow the same rule. We'd also have a conversation with them first, hoping that they will yield to a different practice. You know, that's always our first step.
That's understandable. I appreciate it. Thank you.
Thank you.
I've got a few questions. I'm going to try to say 2 or 3 of them at the same time because you may be able to just answer them generally
Okay.
together. And the first, just kind of to piggyback off of what we just discussed, how current must the study be? How often must it be? And for what period of time is it considered timely, like relevant, like accurate?
So typically, when we get a traffic impact study today, it's relevant to that time and what's going on. If we have a dramatic change in the landscape or the flow, so a good example would be when we're successful with getting all of the adaptive signals in and we're looking at the traffic flow even improving better, that's also going to improve their traffic flow as well, because remember, they got to move with the flow of traffic. If at that time they can't, then we would require that they do another study, because one, we would get the complaints and we'd say, you're not keeping up with what is intended, you're not keeping up with the flow of traffic, you are now creating congestion. We would require them to provide us another study, which would require them to come in and do the methodology, visit with it, and then provide us with the data. Just real quick, something about methodology. We don't do it based on a snapshot of one time. It's over a period of time that we require data to be collected. So just to let you know, it's not like they go out and do 1 day and come bring it in and we go, oh, okay, great. It's more than 1 day. It's quite a few days, because we want to understand, you know, really, as you said, you know, y'all keep saying people can fudge it and everything, but when you have a licensed engineer and they're signing it, they're putting their license on the line. So if we find that the document is flawed, that the data is flawed, or it's incorrect, that person's putting their license at risk, which is their breadwinning tool. So I haven't had that experience where an engineer is willing to do fraudulent work. I hope I never, ever have that experience.
2 quick follow-ups.
Yes, sir.
Is the cost such that it could be prohibited for some companies that want to do this, to be able to do this based on the size of their company, and therefore it is somewhat preferential to the companies that can afford it?
I really can't speak to that, because they can negotiate with different engineers. We don't put a preference of experience, let me not say experience, because that is really important when you're doing a traffic study. That's also one of the reasons we require methodology, is so that if it is someone that maybe doesn't have quite the experience, we're going through exactly what it is they need to do and how they need to deliver the data back that would support the recommendation.
No, I just mean if it, let's say it costs $2,500 to do it.
I can tell you, engineering firms cost, engineering firms cost different things. They would be able to negotiate that. So it's hard for me to pin down the price.
Okay. And then my last one is, what happens if there's one study that says it meets, and then maybe a organization that's not in favor of this has their study say, no, it doesn't meet?
again, they could go back and do the study based on the methodology and see if it meets. They can adjust their operations to have it meet and bring that back to us. So, you know, it's really gonna be them meeting their criteria, making sure they stay with the flow of traffic.
I think my concern is there's more than one potentially company that could be performing these studies, and you could have a conflict based on their perception of whether or not it meets or not. And so one company could say, one survey company could say yes, the other might say no. And how do we resolve
So,
that?
again, we're giving them the opportunity to hire their engineer. Their engineer themselves come in and we have a methodology meeting. All the criterias are laid out at that time. If they can't meet that criteria, they're not eligible. If they can meet all those criterias that are established in this methodology meeting, then they would be eligible to operate between 4 and 6. And again, if they start failing and not operating according to what they provided, we would then bring them back before you requesting a revoke in that permission to use it.
Thank you.
You're welcome.
Okay, I have a lot of thoughts here. I'm a little surprised, honestly, when we started that Mr. Rosenblatt and Mr. Winters were opposed to this rule, because I think they would like to operate between 4 to 6, and it's not limited to just the sightseeing vehicles. So I'm surprised that you all were actually opposed so adamantly to this. Okay. Well, we're here. This is pretty transparent. This is the opportunity for transparency. I got this in the same, when you all did. So, that was just something that was surprising to me. I value data and the studies that would be linked to this proposal, but I also have my own experiences of working downtown and with these vehicles, and I'm torn. There's things about the sightseeing buses and the entertainment vehicles. I mean, they're all entertainment vehicles, but the I'll just call it a party bus, that they operate differently. Like Mr. Rosenblatt, he has people, he picks them up out of the fray, out of a different place, and they're going with the speed of traffic. They're not stopping. And honestly, that's not causing me it's the activity on the bus that is of concern sometimes, as opposed to, and the loudness of it, and while you're trying to get somewhere, as opposed to the start-stop. Meanwhile, with the sightseeing, the stops are in places which you have alluded to, where they're picking and dropping off people, and they're in the middle of those places aren't always the best places. And they're not just like one bus that's on that route and they pick up and then it's gone. Another sightseeing bus comes in, and then they're parked there, and at the worst time in this 4 to 6 range. So I've asked some, people just that live in Nashville about their thoughts about this change, who appreciated the 4 to 6 restriction, and not one of them thought that this was a good idea. So I also spoke with some council members to see if there was some movement at the council level that we weren't aware of, and maybe there is, but I didn't get the sense that at the council level, or maybe it's the mayor's office, I don't know, but I didn't get the sense that this was coming from somewhere else other than the industry who would like to be able to operate during this time. So that's just my thoughts on this.
Let me add one thing in case I did not make this clear. This is a public hearing. It is open to discussion from the commissioners with the industry, with NDOT, with anybody else that is interested in speaking. Would you raise your hands if you are wanting to make a public comment or speak about this? All right. No, that's fair. Gentlemen, you spoke earlier. Let me go ahead and take some other folks first, and then we'll get back. I do hope that this helped clarify. I noticed in both your lawyers' letters concerns about what was, that the agenda item didn't make clear what was happening. I hope by now seeing the addendum to Rule 805, that helped clarify what we're talking about, and that there's no special treatment for anybody. So, yes.
Just one comment on that toward transparency. Anytime there is a rule change, it is posted on our website, as it was here today, a week ahead of time. So this is the meeting page on our website, and you can see a proposed change to the rule listed here and a link to click on the rule change.
Thank you, Mr. Shafley. That's very helpful. So, And that should be helpful to the public as well, to be able to keep up with any item on the agenda that doesn't appear to be clear. Mr. Carr, did you have something you wanted to add? Okay. Does anybody else have something before Mr. Reed speaks? All right, would you introduce yourself, tell us who you're here for, who you're here on behalf of, and share what you want to share?
Yes, sir. Thank you, Chairman. My name is Sam Reed. I'm here representing Old Town Trolley. A little bit about Old Town Trolley and kind of why we're here today. We are a company who's operated since 1970. We've been in Nashville for about the last 10 years. We operate in cities all across the U.S., Boston, D.C., San Diego. Our model is a hop-on, hop-off model where you buy a ticket at any, and then in Nashville, for instance, we have 13 stops. The 4 stops that are at issue today are our stops numbers 7, 8, 9, 10, which started the Country Music Hall of Fame, go to 201 Broadway, we then stop at the Ryman Auditorium, and then at Legislative Plaza. As Director Alarcon indicated, for the last 2 years, because we are considered a slow-moving vehicle just by the fact that we are a sightseeing vehicle, which is a subset, obviously, of the ETV regulations. I have a lot of experience with dealing with the ETV regulations. I was, sort of intimately involved in getting them passed both at the state and at the city to regulate the issue of party buses, which, as you all know, in about 2020 sort of exploded onto our streets. Old Town Trolley, prior to that time, was operating as they had for many years, and I don't think anyone ever really viewed them as much of an issue or a problem that we were trying to solve. However, when the ETV regulations went into place, it was determined that the size of our vehicle and the mode of what our vehicle does, sort of, we were part of the, we became part of the ETV regulations, and then you all at the TLC sort of created a subset of a sightseeing designation. And so that's why we're in the slow-moving vehicle restriction from 4 to 6. All we're here to do today, and what our mission has been from the beginning, is to get back to our normal operations before we were, had the ordinance passed and this slow-moving vehicle restriction came in. I would also like to point out sort of the practical effect. Because of the nature of our business, from 4 to 6, we would make 7 trips through downtown if we were operating normally. Our buses hold up to 50 people. Everybody is seated, there is no alcohol. We are educating people about Nashville history, and we are delivering customers to our Nashville institutions. And we actually have letters of support that I'm going to share after this from several businesses, and some of them are downtown businesses, who are in favor of us being able to resume our normal operations between 4 and 6 on those 4 stops downtown. Now, I understand a lot of the concerns and frustrations about the way the rule might be written, and that folks might come in and try to abuse it. But again, the practical effect we're talking about here is 7 trips through downtown on an Old Town Trolley, carrying anywhere between 25 and 50 people on those trips, moving 200 plus people during that time. And if we're worried about traffic and congestion, I would actually say that the restriction, certainly as it relates to us and our business model, is only adding to the traffic burden, because all those people that bought a ticket for the hop on, hop off from 4 to 6, they can't utilize our service anymore, and they then have to go seek out another mode of transportation. And so really, we're here today to support NDOT. We think they've taken a responsible approach here. One other thing I would note is in November, when all locals get to ride free, we hosted a policymaker ride. We actually invited the members of the TLC and staff from NDOT. We had about 10 plus council members on, really to show folks like kind of what it is that we're offering and why it's different from all of the other vehicles that are classified as ETVs. And I think we've done a good job of convincing people that we are not the problem, and that I think by and large, folks would like to see us operating again as we had for many years before these restrictions went into place from 4 to 6. And so that's why we're here today. Again, this is the method that has been chosen by the city in order to, that we would absolutely want to take advantage of. But I can understand your heartburn and happy to answer any questions.
I'd like to make a comment. First of all, I appreciate you being here. I remember when this room was full of ETV operators and scooter operators and buses and limos with jacuzzis in the back and the whole nine. And I want to say the fact that I want you guys to realize no one snowflake is going to make a blizzard, but all of you guys together can produce data or support from your patrons saying that they're so happy you're here. I'm sure he can. I'm sure everybody who has a golf cart down here can get a patron to say, it helped me out to get around Nashville while they were here. Not the problem. I think it's a combination of how all you guys together move in downtown Nashville. And with NDOT having the mountainous task of trying to make that work and please everybody at the same time, having 6 kids, I'm gonna tell you, it's not possible. It's gonna be the best that we can do. Part of the problem, I think, with your particular company is it's not seen across the board as operating fairly, being that you're able to use the WeGo stops, and they're not. They're watching you do it, and they're not able to have that. Your argument is we're not them. We move in a different form and we move in a different fashion, but you all are in the same industry, and you're all in the same downtown corridor, and you all would like to move that way, and we have to be fair as well as safe. And when they say we can move just as fast as you, then we have to take that in consideration. And NDOT has the burden of proving that yes or no. Some of it is going to be cost. There are a lot less of you here simply because the other companies couldn't afford to be here. We have a lot less scooters. Excuse me. We have a lot less scooters downtown simply because they couldn't afford to be here. They couldn't afford to geofence. They couldn't afford to pick their scooters up on time. And what I think we all need to consider here, and you guys have been here in the past and so have you, is that we are working toward a solution, and it's not always going to seem fair in that time frame, but we are working to get it fair, and it's not going to, the landslide is not going to go either way. The landslide has to go towards safety and the people who live in the downtown corridor. The mix is for the people who visit in the downtown corridor, but the actual objective is for the people who live here. We're here day in and day out and not spending the weekend saying, I'm getting married. We have to keep our citizens safe and those who are visiting us safe. And we also have to keep the business practice that you guys have endeavored to be in as fair as we can. And NDOT is going to have to do studies on that we're going to have to abide by until we know different.
Mr. Rosenblatt and Mr. Winters, I'm going to give you an opportunity to speak also, but I want to let the other folks that didn't speak earlier, okay? Is there anybody else that wanted to speak? Yeah. Yes, of course. Speak up.
There it goes. Would you support total repeal of Section 805F? So that instead of just one company or companies that can afford to study, every company could operate 4 to 6?
In my personal capacity, or as my capacity as representing?
Whatever capacity you're there, Sam. That'd get you what you want, right?
Yeah, I mean, look, all along, and I already went through the history here, I mean, we fundamentally think we're different. I mean, and to Commissioner Carr's point earlier, I mean, you know, I think that there's a public value that we are providing that should be taken into account here.
I don't disagree. Where I'm at is council threw all this to us.
Correct.
They didn't differentiate. In fact, we've tried to. And at this point, I'm ready for council to deal with these issues. I think you are different, and I think they should be the ones to decide how different you are. And which is why I bring up the issue. I would say let's do it the same for everybody. And if everybody's not the same, then let the decision makers for Metro make that decision.
Mr. Reed, what is the public service you see that you distinguish your company in?
Chairman, I would love for you to come on an Old Town trolley ride.
Just tell me what the public service is you're telling me.
I think, you know, as somebody who really values our, you know, tourism and cultural institutions, many of whom we have partnerships with, you know, we are delivering, I think, a unique experience for people that are coming to visit our town. We're telling them all about our history. We're highlighting our, like I said, our cultural institutions. We go out to Centennial. We take people down Music Row. And again, we're getting people excited who are, I think, people interested in Nashville's history that are here for the right reasons to, you know, learn more about all of the things that you can experience in Nashville. And then we're delivering customers, like I said, to our major cultural institutions. We are safe, we are seated, we are quiet, we are, our customers are not drinking alcohol, and we think that we are offering an extremely valuable experience, and that's why, you know, we operate in many cities where people want to learn about the history of the city.
Okay, I thought maybe you might be referring to moving people from one destination to another, like a bus service is, but I guess that's not. It sounds like to me what you're offering is entertainment to people who are visiting the community, to learn about our city, to be entertained, to go to restaurants and see some of the cultural things.
Correct.
Which is why I think sightseeing also falls under the ETV umbrella, because they provide entertainment. It's different, but it's entertainment, and it promotes the city to people to come here and pay money and pay that visitor's tax. That helps to support a lot of other things in this city. So thank you.
Yes, sir. I mean, that is also a value. I mean, we have, in the last 2 years, we've moved 250,000 customers around.
I'm not disagreeing with that. Yeah. I'm just wanting to make sure I understood what the service was that you were referring to.
That's part of it. Thank you.
Ms. Alarcon, I just want to make sure I understand something. If this amendment were to pass, a company owner in the transportation business could come to you, or would come to NDOT. They present their studies, and if NDOT decided that they didn't meet the criteria of that paragraph, and maybe with some more specificity that will be added to it, well, it certainly would not be coming back to this commission for approval or denial, right? Each request is not going to come back on our agenda.
It doesn't. The idea would be, again, as some of the exceptions, such as the fixed route, would be Ricky and then the
Right.
NDOT chief engineer.
We're not going to have to approve or
No, sir.
not approve.
Correct.
Okay. Then number two, if someone's dissatisfied with a decision by Director Rooker or NDOT, are they able to then sue, and who would they sue?
I'm going to turn that over to the attorneys.
Oh, yeah.
I think if they were dissatisfied with the decision, they could.
Who would be the defendant?
Metro.
Any particular department, agency, or?
Well, generally you sue Metro.
Okay.
Yeah.
Not the chairman of the transportation.
But, I mean, they could.
They could name
an individual Metro employee.
I'm sorry, go ahead, please.
They could name an individual Metro employee
But generally,
as a
we,
defendant.
but
So
we
it'd
generally
be-
move to dismiss that under the GTLA, so.
Mm-hmm.
Metro
So-
would be the proper party, is what I should say.
So it would
Now,
be
who they
w-
sue, I don't know.
It would be really important that there was a rational, reasonable basis for the decision made by Director Rooker and NDOT.
Yes, sir, and that's why it's very important that they not just show up with the study, they do the methodology, so that it's all laid out, it's outlined, and it's documented and we have it on record. And therefore, if they cannot meet that methodology, and again, this is already pretty much lined out in our multimodal transit analysis requirement. It's a document that we actually have online. They would then get denied based on the fact that they did not meet the criteria that were established in a methodology. And that is something that is agreed upon by both parties sitting there. So it's a meeting with us, the traffic folks, and then it's a meeting with the owner and their engineer. And then there is an agreement that we come to on that methodology, and they're gonna work on getting that data for us.
Okay, so I'm gonna defer to the lady, go ahead.
Sorry, I forgot we're on all the time. My question was gonna be is if we talked about the operator could seek this study, could operators get together as a group, a coalition, and say, we're all, similar in this, we're all, can they just all 100, however many there are, 91 of them, get together and do one study and submit that, or does it have to be individual, like,
I would say
ownership
it's,
groups?
I would say it would have to be by individual because it's gonna be based on the vehicle that they're using.
Okay.
So it would be the impact that their vehicles would have, and they use different types of vehicles. And they carry different number of folks. They have different safety practices. So all of that's gonna be part of the methodology that's gonna go into place. And again, that's something that is written down, documented, and agreed upon by both parties. So they know exactly what to do and what data to bring back, and we're not gonna vary from what we have already established and agreed upon as a group in the beginning.
Okay, I'm a tad bit confused, and maybe I'm a little dusty from being here. If NDOT is going to determine whether or not they meet the regulations after meeting with their engineers, but we're licensing them to be able to operate, why are we in the mix at all?
You're in the mix for the request of the rule change.
Right, but we're also, if they are operating between 4 and 6, you guys are gonna come back to the board to say they are operating outside those parameters and want us to revoke their license, but you guys hold the power to give them the permission to begin with. So I don't understand why we're not just taken out of that altogether.
So we do not have the authority at this time to revoke a permit that's been issued. And so the way we do it now, if you recall, we provide y'all with the complaints and then with our recommendation, and then y'all make a decision based on that. So again here, if we approve the study and it's not a problem and life is good, it operates as the same, they're with the flow of traffic, but if they provide us with the study and then we find that it's not actually correct or we're having problems and we have conversations and it doesn't improve, I have to bring that recommendation of revoking that permit back to you.
Right, but you have the initial ability to give the permit after sitting down, so that doesn't come to us.
So, no, it does, the permit is actually approved annually from y'all, and this is a rule. If they fail to follow a rule, and we wanna take, a disciplinary recommendation to you because they're failing to follow a rule, I do not have that authority, Ricky doesn't have that authority, that has to come back before this board because the discipline action would be revoking the permit.
Or it could be
So-
other
Or
disciplinary
it could,
action as well.
and that's
like-
for this
yeah.
board to decide, not for
Right.
me.
But why are we not
or us.
given the decision to give them the right to operate to 4 to 6?
So the rule right now, it's a rule. So right now, the rule does not allow anybody. We're asking for an amendment to be attached to the rule. So you're adjusting the rule and regulation. That's the request before you today. So we would you annually permit them, and then we make sure that we're enforcing the rules. And so this rule is saying that they can, if they can provide us with the appropriate, come in and do the methodology and provide us with the data. Us being NDOT, and it being Ricky as the director over TLC, and then our chief engineer who has the specialty and the knowledge. If they say, yes, it meets all the criteria that's established in the methodology meeting, then they would be able to apply this rule. If it does not, then they would not be able to apply this rule. So it's a rule change that we're asking for. We wouldn't come to you for a permit. We would, as usual, we provide you with information of things that are happening out in there. We'll, from time to time, when we get those complaints, we provide that to you. Even if we don't want to take any action, we just want to make you aware, we would do the same here. It would be more of an informational, just to share with you what is happening.
It's just a little weird to me that the permission is actually part of the rule, that we made a decision on to give them operational go ahead. I mean, this 4 to 6 is part of their permit.
It's
and so
correct.
If we, and I guess the conundrum that's going on in my head is there is another decision over here being decided as to who gets to operate 4 to 6. And it's not coming before us to determine, is this a fair decision? It's only coming before us when another party decides, I don't think they should have it.
No, not that they should not have it, that they have violated the rules in some way, and they're
Right.
coming up for discipline.
Right, but it's still, the 4 to 6 permission is not being given by the board. We're just giving them permission to operate. The actual 4 to 6 limitation is being lifted by NDOT.
The amendment is to give permission to operate from 4 to 6 if they meet a certain criteria that will be reviewed by the experts at NDOT and Director Rooker.
Okay, so Director Rooker is our stand-in, okay.
And otherwise, it would come before us with traffic studies and testimonial, and we would be bogged down constantly reviewing the different applications. And frankly, I think Director Alicon admitted that she was not an expert on analyzing traffic studies. I would rather have, it's like having a special commissioner appointed to review the traffic study and make recommendations, and Director Rooker to look at the routes and keep us informed.
I'm playing devil's advocate as to, I can see someone coming saying favoritism is being played.
I got a question. I guess maybe it's a thought, it's a question, but couldn't a traffic study in March reveal one thing and a traffic study in July reveal something totally different?
Yes, it can. And so, but if they're meeting the criteria at that time, we would permit it. And then if we are having issues and problems, that's when we would sit down and have a conversation and say, this isn't working. And so then it may be requiring a change in operations to fix that. But they, again, the one criteria that they have to all hit is that they are flowing with the traffic and not creating the congestion. And if they can't do that, then at that point, we would bring that back for you, because it would be their failure to follow a rule in which they provided us with data, but they're not meeting the intent of the data. So therefore, our request would be to discipline or revoke the permit. And that's what would come back before y'all.
I think I'd be concerned as a vendor if I spent whatever it cost to do this, and then the situation changes a few months later. I would feel like that was unfair to me.
Well, if the situation changes later, I'm expecting it to be in the positive, not in the negative, because of the ongoing improvements we're making through Connect Downtown. But if, it could change in July. If we have to do some type of construction and that could be a barrier, we need to take that into consideration. But if construction's causing them to slow down, it's causing everybody to slow down. So that's why it's saying move with the flow of traffic. But typically, if they're not able to consistently move with the flow of traffic, then we would go back and look at the study and the data and figure out what wasn't right. And that's where the conversation would start first with the owner. And that's why the methodology meeting, and that is a practice throughout the industry, that methodology meeting that everybody agrees upon, this is your study, this is how you're gonna do it, this is what days you're gonna look at, A, B, C, D, E, F, it's all documented, it's all played out. They're agreeing to it at the same time that we're agreeing to it. So that way we're holding each other accountable. And so if we find that something in that criteria is not being met, yet the data showed it, but it's not being met, we're gonna go back and make them redo the data because it was not correct. Or we're gonna figure out what's causing it. And 9 out of 10 times, they already know what the cause is and they share it with us. And then if it's something we can fix, we fix it. If it's something we can't fix, then that's a discussion we need to have with them.
Is there anybody else from the public that wanted to share some comments with us? The gentleman here in the middle had raised his hand. You don't have to. I'm just, I know you raised your hand earlier, so I was going to get your phone out of your hand. So,
Should I stand here? Or?
If you're going to make a comment, you need to sit there. You need to introduce yourself.
My name is Andrew.
Yeah.
And I'm originally from Egypt, but I've been living in Nashville for almost 18 years. So this is pretty much my home. It's great to be here and hear all these good things about our society and community. We're just having a very specific issue in downtown with the potholes. Like those can like hold the traffic and make what seems to be normal traffic not normal, and people going slower than the speed limit because of the potholes. So I don't know which agency or department are responsible for that, and should we or even like we have a plan and we don't know, like I'm just concerned about this. Thank you so much.
You're welcome. We'll see if we can figure out which division of government deals with potholes for you.
It's mine.
Oh, it is? Okay. Well, the message has been received.
It's either T-Dot or N-Dot. I graduated from TSU and I studied a lot about traffic and civil engineering, and that's why I was interested. Thank you so much.
You're welcome.
The Hub Nashville app is, as many people here know, I post to it. Time to time. Things that I see, scooters, potholes, UTVs, buses.
Please.
But I'll tell you, I had a bad pothole on my street last year, and I posted it, and it was fixed within 48 hours. It was exceptional service.
They knew it was you.
Really applaud.
Yes, if you could, if there's a pothole, because we don't have folks that can be everywhere at one time. So if you report it at hubnashville.com and you put it in the location, we'll be able to get out there and get it fixed. If it's T-Dot, we'll let them know it. Sometimes we fix T-Dot's holes too. So just put it in Hub Nashville, please. And again, that's hubnashville.com. And that will get,
It's .gov.
Yep.
Yes,
Yep.
there it
It's
is.
up on the post.
Please, help us do a better job.
Director, it's nashville.gov.
Oh, I'm sorry, hubnashville.gov. Sorry about that.
It's not just like one or two.
No, report them. Report them all.
I'm thankful that I'm speaking freely, but the whole downtown area is really messed up. I mean, I can just guess that at least one business makes $1 million of income a day. But the streets and everything else around downtown, it's just a mess. We got some potholes that are really dangerous even on the highway. I had to change my tire like 3 times one time in 1 week.
So
I hit the same pothole.
I will tell you we're not responsible for the highway, so please take that to T-Dot. But on the local streets, if you would put it into hubnashville.gov, we are typically out there in less than 48 hours making the repairs, because we do not want the potholes either.
And what if I wanted to put like the whole downtown area?
You have to be a little bit more specific. I would prefer if you find what you think are potholes between Demonbream and Broadway on 3rd, you can put it in that way, we'll hit the whole street. But if it's in one particular area, put that in for us, please. Again, hubnashville.gov, he has it up there. It helps us because we don't see everything. And so we really do count on the community to help us do a better job.
And that is our public service message for today. Now, And Ms. Barker, I'm not going to ignore you either if you had some more that you want to add as well. But Mr. Winters, you were smiling. I think I might ask you if you had anything you wanted to add to the public hearing today.
I do as much as you may not want to hear today.
Oh, I was going to catch you smiling. I was hoping.
We can both sit.
You can sit up there too. Go ahead, Ms. Barker.
Yes. Just the one big question that I had in my earlier public comment was, it was not clear to me if the new proposed red language is just further clarifying what the black language says, meaning that's how you get your exception to the rule to operate outside the no-go zone, or if getting that engineer provided study done and getting your exception allows you anywhere in the downtown. So if NDOT would be able to clarify what the intent of that is, I think that's important.
This would allow them to work in the, to operate in the downtown area during the hours of 4 or 6. So this, if they meet the criteria of this exception, they would be able to operate like they do normally any other hour.
Anywhere.
Great, so that is a clarification. I would propose then that that means that the latter half of the original language probably needs to go away, correct?
Not really. We start with a prohibition of 4 to 6 unless you meet the exception in the lower paragraph.
I think she's referring to the only operate on routes and zones.
Right, and on routes or zones outside of that no-go zone is how it was originally written.
Well, I would say that needs to stay intact because there are some vehicles that we know, such as pedal carriages, that will not be able to operate no matter what at 20 miles per hour, that may want to come in and do a fixed route. So that's going to allow them that opportunity.
So the proposal before the commission today is not for pedal carriages, but for entertainment vehicles, and that if you don't have your engineer provided study, you're not operating anywhere between 4 and 6, but that if you get your permit to operate between 4 and 6, it is anywhere. Without an approved zone and disregarding the KVB to Union and 1st to 8th, I don't think that that's clear. I would argue that that's not clear in that language.
I think my understanding of this rule is if I'm in an entertainment transportation company, starting out number 1, Monday through Friday, 4 to 6, I cannot operate. Step 1 would be I want to operate, but want to operate outside of downtown, outside of this 1st to 8th Korean Veterans to Union area. Then I can get approval to operate on a route if it's approved by the TLC director and the chief engineer. So I can be on a route during 4 to 6 outside of downtown. Next step is if I want to operate in downtown, then I'm going to seek an engineer to perform a traffic study.
And I think to make that, yeah.
Depend on what the methodology should be first, which is subjective because it's going to be different from every single company. With your chief engineer and with Mr. Roker, come up with the methodology, agree on it, and then do the study. And the methodology is something that we don't see or have any input over. And then if there's a problem, it could take, you notice that there's a problem, and it could take, how fast could it happen?
I think that's kind of hard to say depending on what the scenario is. You know, so.
But if there's 7 complaints, right? So that's the hard part. Like, you could have 7 complaints but you impact 10,000 people because 7 people know how to get to Hub, or 7 people know how to email you, or 7 people email their council member, right? It could be a really bad problem, and it doesn't.
And depending on what the problem is, you know, we respond right away. So if it's a really bad problem, then probably nobody's moving, and then we need to look at fixing it for everybody. So, but if it is, and you know, in that case, if it's just relevant to them, to me, it's an operational issue that they're applying that we need to have further discussion, that they're not meeting what was established through the methodology and hitting all those criteria. And then that discussion would be with the operator and the owner, and they would need to alter it. If they don't and the problem continues, then again, we would be bringing that back before you with a request of discipline. But we would always try to resolve it first, because sometimes if it's us needing to do something to improve the roadway condition or tweak something, it may fix it, but if it fixes for them, it's going to fix it for everybody, and that's a win. If it's something operationally that they needed to make adjustment on, but they haven't, then we would actually make that recommendation to them, tell them they need to do it because they're not meeting the criteria that was established as part of the methodology of the study, and therefore they are opening themselves up for discipline that we would be bringing back before this commission for consideration. And again, that discipline can be whatever y'all desire or revoking the permit.
Mr. Winters, what do you want to share?
First, something I wanted to say, and I think Mr. Reed was very candidly too nice to say it. When you asked the question of, would you, I think maybe over here, asked the question of, would you not open this up to everyone from 4 to 6 and just make this simple? I think what he was trying to very nicely say is his operation is much more wholesome than my trashy operation, where we have a little more party style versus the historic parts of Nashville. And while I don't disagree with that comment, we have a sense of humor. We are slightly funny. We're not as wholesome as what they operate, and I own that one. But I don't think this board should take into account whether you own a Hooters or an Applebee's when you're passing out permits. It should be about the business, not about wholesome or not. So he was very kind not to say that, but I'll say it on his behalf. The secondary part that I'm wondering is, I feel like we're building a rocket ship to cross the street, and I think there's an easier way to get there. I have 30 videos on here that you guys can watch if you want that show Broadway from 4 to 6 during the heat of the summer. There's no traffic. There's nobody on Broadway from 4 to 6. I don't understand what we're trying to fix. I understand the process of how we got to where we are. I understand we have an approved route that allows us to operate outside of the downtown core, which to me, and I think there's some council members that probably agree, you're pushing us to the interstates where people are trying to go home, but yet Broadway's empty. I guess I don't understand very candidly why we're going through all this dance when reality is from 4 to 6, we probably should be on Broadway. We probably shouldn't be some of the other places that we were pushed to based on some of these rules, which don't get me wrong, I appreciate. I like operating from 4 to 6. So I'm not trying to cut my own hand here, but I do think if anybody wanted to, once again, I'll leave it with if you want to, there's videos all summer long of no traffic on Broadway from 4 to 6. I just don't understand where we're going on that part.
I will interject. I try to get to Broadway on 2nd and 3rd. I own a nice surface parking lot there where I park every day.
Yes.
And trying to get through Demonbreun, trying to get down 2nd and make a left onto Broadway, getting stuck behind a bus when I shouldn't, right? Because it's blocking a couple lanes of travel.
Yes.
And then you go down Broadway and the signals aren't timed, right? So you get stuck at every signal. You get stuck in front of the Amazon where there are delivery drivers that are stopped when you're just trying to get to the interstate. So I don't disagree that it's and I don't think anybody disagrees that it's got a lot of capacity. It does, but it's not flowing.
And I agree.
So it could flow. Could flow.
Yeah, what I hear is there's traffic and signals, improvement coming. There's technology coming. There's 6 cars stacked, lights change. And what I'm hearing is technology that fixes the theoretical problem of lights not changing in order. And I think what I'm hearing a whole bunch of discussion on methodology and do I want to pay for a $20,000 traffic study and then by the way it's not right and I got to modify it a month later for 10 grand. And what about the one guy's got one permit that has a bus in his backyard? This is a part-time job. He probably didn't have the 10 or 20 grand to buy the permit in the first place. Or the traffic study in the first place, much less modify it every time the flow of traffic changes. And that's why I called it in the very beginning, pay to play, because you got a one bus operator who you're asking to follow rules that very candidly, maybe not everybody can follow. And the secondary part of that is, this is the KCI study from 2018. And for those of you that weren't on the board, I'll give you a little background. In the first part of 2018, KCI did a study on pedal taverns, horse and buggy, and something else, and said, you guys are too slow, you're off the road from 4 to 6. At the very end of that meeting, if you go back and watch the video, they said, well, let's throw golf carts in that too. Well, golf carts weren't in the study. So myself and others went to Billy and said, hey, something about that's a little screwy. Can we relook at this? Well, they did another study and came back and said because they, from the manufacturer's spec, because they go 20 miles an hour, they're released. The whole industry was released because of the KCI study that said if you did 20, go for it. You're not slowing down traffic because the average speed at that time was 12.4. I'm not sure where 20 came from, but it was 12.4 in 2018 when this study was done. A little more data on top of that. If you look at TDOT's traffic count studies, traffic in 2013 was more than it is today on just about every downtown corridor. I looked at 14 different streets and I was very candidly shocked. The traffic in 2013 was thousands of cars more than it is today. So I'm having some issues with some of that data, but where I'm going with this study is, and I'll use Grant as an example because I'm on the oddball, I got a tractor. Use him. All those party buses are about the same. A lot of them are school buses, a lot of them maybe are motor coaches that are a little nicer. If one bus passes the spec, why don't they all pass? Why is everybody doing something to study 14 different school buses that were all made probably in the same 10-year period? I don't get it. And I think, and once again, I hate to say this out loud, but when you start dealing with one person has all the authority to decide whether you qualify, and then by the way, we may make you redo a study over and over and over again, that dangerously sounds like a pay-to-play program. And I'm not saying that's the intent, but it sure can come across that way if you're not careful. Same way as you mentioned, some of the operators are no longer in this room. Why? Permits got expensive. Insurance got expensive. You had to pick up and drop off at your own property. Some of those people were weeded out because they couldn't pay to play. But I think it's a slippery slope, I guess is my point. Has there been a study done already that NDOT's already reviewed? Is a question, and maybe I'm not saying Ms. Alicante has to answer, but I'm curious. Is there a study already done showing that a company or companies already qualify, and is that why this rule is on the table? Because I think Mr. Hayes mentioned a while ago the studies that we have been emailed. Maybe those are previous studies. I'm not sure about it in relation to this event, so I don't want to put words in your mouth. But I'm curious: is there a study already done that is drawing this rule to the table? And if so, is anybody willing to answer for whom has it been done? And I don't, once again, she doesn't have to answer. I'm just throwing it out there. Bear with me 1 second, sorry. And I hate to say this because I know I sound awful saying this out loud, but we're putting all of the authority into NDOT to review studies, make decisions, methodology that supposedly looks at routes, turns, speeds, how you operate, and all that kind of stuff. Then I would like somebody to really explain to me how a route got approved that uses multiple bus stops, that's on their route, that uses multiple places where there's no loading zone, but yet they're allowed to stop there and load and unload, that was approved by NDOT. That didn't come back in front of this commission to go, hey guys, we got a problem. Do you know that stop is at Rosa Parks on a lane of traffic that they have to block? Is that a good idea? So I agree with Mr. Carr. I think going back in front of this commission to maybe look at things that somebody else maybe overlooked, because very candidly, maybe NDOT was looking at the physical route, the physical streets, the diameter of the roads. Maybe they didn't look at the fact there's a bus stop there. Maybe they didn't look at there to see if there's a loading and unloading zone there. There's a shadow of doubt, but I also am curious how dozens of pickups happen at a bus stop in front of farmers market every single day and nobody notices. Well, I can tell you why it happened. Farmers market's a state park. To go through that state park, if you happen to operate 20 vehicles, it costs you $5 or $10 grand a year for permits and insurance. So what do you want to do? Avoid the state park. You want to go around it. That's why the bus stops are being used. But somebody had to approve that route. I'd prefer that to be you guys who oversee it and have more thoughts, affect traffic patterns you drive home on and all those things, to maybe look at some of the things we're talking about. No offense to Ms. Alicron and NDOT, but I think that was a big cluster in approving a route that uses better state-funded bus stops. I think that was probably an oversight that maybe you guys would catch. You mentioned flowing with the speed of traffic and how vehicles are different, and I do agree. The one thing I will say to my caveat and to Grant and some of the others is we don't stop anywhere. Yes, we may not be the fastest acceleration, we may not be the vehicle you want to be behind, but we don't stop. So, but yes, but I will give you this.
I hope so.
So the guy, I'll watch one of your
Yes.
tractors try to make a right on second on the cable T and a left on the first. And that turn movement, the same thing for right, second on the Demonbreun
Oh, it's a large, we're like a semi sometimes. I get that. And I don't deny that one. But what I'm saying is when we're talking about the differences of companies, and really I don't think that should matter too much, when you're picking up and dropping off at 13 stops throughout the city, that is different than Grant, who doesn't stop. He just goes, other than hard turns or red lights or whatever. But my other concern is KCI study, which to me said golf carts are free. I can accelerate faster in a golf cart all day long. I can stop faster in a golf cart. I have a faster top speed than a golf cart. So in 2018, when golf carts were released from 4 to 6 band because of the KCI study, which is paid for by the city, and my vehicles accelerate faster in a golf cart, stop faster than a golf cart, and I don't understand why this study, very candidly, is not already some of the proof that if you can go 20 miles an hour according to manufacturer specs, you don't meet the same standard that was previously used in this same room to release golf carts from 4 to 6.
I believe I was here doing that study, and I believe part of the study took into account the size of a golf cart versus the size
that
of
would
your
very well be
vehicle.
true. Yes, I'm cliff noting, obviously.
They get a chuckle from you or you?
Another point that, and I brought this up before, but I'm curious. NDOT has said in every meeting that I've been to that her number one objective every single day is safety, and the number one item on safety is pedestrian safety. I still struggle every time we talk about speeding up. And we've had this conversation before about turtles in the road, and sometimes a turtle in the road is a good thing. There are 20 to 30 traffic calming studies going all over Nashville about dropping speed limits, putting in speed bumps, whatever it takes to slow down traffic, because believe it or not, if you get hit by a car doing 20, you tend to live longer than one doing 40. So when we're talking about going faster, I always look back at those traffic calming studies to go, well, what's the objective here? Is the objective, I don't like this certain style of vehicle because you're too big, you're too rowdy, you're too noisy, or whatever it is? Or is it because you go too fast or slow? I don't know if there's ulterior motives there, but if you're slowing traffic down all over town, I don't see a problem with slowing traffic down in some areas that are the entertainment districts of Nashville. Just side note. I think this was clarified already. Ms. Alicon mentioned, revoking permits. Obviously, if you happen to pass this rule and you are allowed to operate in 4 to 6 in the downtown core, I think that's a traffic citation. I'm not sure it's a revocation of a permit because you didn't meet the standard that you tried to apply for, or whatever the criteria might be. I think revocation's a little much, and I think the state law probably tends to agree with that.
Just real quick, I think that would have to do with frequency. If
I would
you just,
agree.
I can afford to pay this every time.
Yeah, you paid 42 fines. I'll use the example of Curtis, that got his 92 citations and finally got his vehicles revoked from permit. Okay, yeah, he probably went too far. I get there's a part. Well, no permit as well, but there's a point. Yes. Just when I heard the word revocation, my skin, obviously curls up. And we also talked about how we got here, and and Mr. Carr's been around long enough to see this, and some of the others have well. If you remember, it wasn't too many years ago, as we were talking about entertainment transportation vehicles and permits, and people liked us and hate us and all the other stuff. There was a whole back room full of a bunch of shirts, for Safe Fun Nashville. They were everywhere. They were taking videos all over the place. And I say this, and once again, people don't like when I say this out loud, but I'm going to. That was a paid group. They were a fake community society. They were paid by people that wanted to influence this commission. That's why they showed up, and that's why you don't see them anymore. There's nothing else to complain about. They did the best they could, and people start writing them checks. They don't show up anymore. I have I understand downtown partnerships got a job to do, and other industries have a job to do. But I can tell you, I wrote a $2,000 check to the NCVC for double platinum membership, but yet in their own meetings, they have meetings about how they're not going to promote companies like mine because we don't fit what they're looking for. But yet they were glad to take my check. So there are powers to be outside of this room that are trying to influence these plays as much as possible as well. Outside of that, those are my major points. I think we have to be very, very careful that we're not building a pay-for-play. I think you've also got to look at the fact you've got a guy operating one bus. Should he not be able to have a business? Maybe it's his lifelong dream. Maybe it's a side hobby. Maybe it's how he pays his bills. I think when you build a system that requires a very expensive traffic study under methodology that maybe is to the point you have to hire a much higher qualified engineer that not just your average guy with an engineer degree can stamp off on, I think you're building an environment that you weed out the little guy that maybe this is something he's wanted to do for a while and can't do. And I think that's a slippery slope. And then I also think that anytime there's one principal that can drop the hammer, that makes me nervous. I'd prefer to look at all of you and you guys drop the hammer and me have to justify my story to a panel of my peers, if you want to call it, versus, one person swinging a gavel, and that always makes me a little nervous. But I would highly recommend, as much as maybe nobody wants to do it, that 4 to 6 time slot. There's nobody on Broadway. I think we're making a big fuss over something that probably isn't worth fighting over. But that's my 2 cents.
Thank you, Mr. Winder.
I want to answer something you said
Yes, sir.
real quick, so you don't say it again. There is always going, and every community has the right to form any type of organization they have to promote the agenda of their community.
Totally.
Or their belief.
Yes.
And follow any senator and
Yes.
in Congress, and you'll find 1 million people behind them. But also the fact that this America, land of the free, home of the brave, and everybody have an opportunity, but in your industry, everybody should not have the opportunity to play just because they can find a rusted bus and paint it,
Oh, I totally
look like
agree.
a cow,
Yes.
and run it down our streets. It's a safety issue, and I would love to own a string of Walmarts. I don't.
Yeah.
I don't have the money. So for every dream that you're right. That one guy's dream, nobody really wants to crush it, but if his dream can't be met by the means necessary, it's a necessary end to keep the public safe. Some of these studies, trust me, I'm buying all kinds of licenses and insurances. I'm not in the same industry
Yes.
as you, but I'm paying for trucks and fees myself, and it can get monotonous. And unfortunately, you've been here a while, but this is where Nashville is still super growing. This industry is still, it's not even a teenager yet.
Oh, we're babies. I get that.
So,
and that's why I welcome regulation very candidly. I've been part of drafting just about everything we follow.
And
I
you
get it.
and
I
you
do.
and to your point, you bring across some great things to think about, and you bring across some great points, and I love to hear you get up there and talk. It makes me think. It makes me think.
Don't motivate me.
and I know you say I'm sorry to say that, but most times I don't think you are. But
I'm not.
So, but I do appreciate all the things that you bring into this meeting for us to think about. I can promise you they're not all going to go your way, but I do appreciate you bringing, and you make some great points. And so I don't want you to think that your presence is annoying. I welcome it.
I'm sure there's some people probably wish I had a little more professional tone, but that's just the way I am, and I don't know how to fix that part. I will say, you mentioned safety. I said we'll throw this out. You do realize that WeGos run anywhere from 20 to 50 miles an hour while people are standing. Just side note. I don't know how that standard should be any different from entertainment transportation vehicles that don't go near 50 miles an hour while standing up on a WeGo. Just throwing it out there. Well, I usually don't state stuff that I haven't already proven.
I got you.
Just throwing it out there. Thank you.
Mr. Rosenblatt, did you want to add anything?
I mean, I get to talk, why not?
All right, let me ask you a question. Is it going to be about 5 minutes, or is it going to be longer? Because I was going to let the
Michael pretty much hit all the topics,
all
which
right.
I think everyone in the room already knows about, but look, if I don't talk, I can't complain, right?
Because I want to let the commissioners know we're going to take a break as soon as Mr. Rosenblatt sums up his share with us, to give everybody an opportunity to read these lawyers' letters and then also take a restroom break as may be needed. Go ahead, sir.
Okay, all right. So again, my name's Grant Rosenblatt. I own a company called Honky Tonk Party Ventures. Just clarifying, my company started in 2015 when there were no open-air party entertainment vehicles. In fact, my vehicle was running while they were training their new employees up from Key West because we saw the unmarked vehicles that were going through downtown. So in relevance, we've been around just as long, if not longer, than Old Time Trolley. Gray Line actually paved the way for them if they really want to go back in time. That being said, I want to go back to what you were stating. I've been in this industry since 2012. We started with the golf carts. I went through that process, not only with, I won't name the company, but we went from 3 to 38 vehicles downtown. And I saw all that process from the beginning. So I'm not just coming here as the rusty party bus guy. I'm coming here as someone who started when nobody wanted to move to Nashville. And I mean, nobody. And you know what the big Complaint was back then it was food trucks, oh my God. And the horse and carriage, it was like, it's just incredible to see the arc that is coming. And probably next year it'll be drones putting people over Broadway. Another point I want to make is City Council, they have 3 meetings to address a rule, bring it to the public's knowledge, kind of discuss it. Then on the 3rd meeting, they vote on it. I'm just here today, especially with my lawyer letter, I just didn't want to rush into a decision that we just aren't fully educated about. I don't even understand. I'm more confused now than I was 2 hours ago. So before we rush into something and then go, well, we can't do that for whatever reason, and we waste everyone's time, let's just take the time to understand what the methodology is on all these studies. To Michael's point, there was that 2018 KCI study. It showed that the flow of traffic downtown was 12 miles per hour. Unless we've gotten less busy, in Nashville, then, is there a new study? I don't know. I haven't seen it, but the last one that was bought and paid for by the city said 12 miles per hour. In fact, I called KCI, asked them about that study. They, in fact, confirmed that the flow of traffic was 12 miles per hour, not 20, again, unless there's a new study that has not been emailed to me. But here was the caveat. They said they had to redo that study not once, not twice, not 3, but 4 different times because of the way they put things onto the road. Someone's car parked on it, a street sweeper. So we're looking at getting a one-time study that could have to be redone 4 different times because of errors or miscalculations in there as well too. I just thought that was interesting that even at the city level, they had to redo it 4 times. And again, someone mentioned how much does it cost? It costs anywhere from $20,000 to $30,000 to perform one study. That is a lot of money. That's salaries for some people. I looked it up. What we're asking is if I pay you money, I get to play. And if that's not pay to play, which I did look up the definition, it looks like there's being a demanding of fees, which when we went into the process of getting everyone permits, we asked if there should be a financial piece to this. Like, should you have $1 million in the bank or be liquid? We were told no, that it was unfair. We couldn't do that. And now here we are saying, now we're going to change a rule that says each individual company, no matter how big or how small, has to come to the table with $30,000 to perform their each individual study. Okay, well, what happens if a month later traffic happens? I don't know what's going on. Then I have to get that study redone. There is no floor. When I get a license to run a bar, I have a license to run a bar. Now, if I mess up, I get citations and all there, but I don't understand why we're having to go back and spend another $30,000 to redo a study because a Preds game happened, which brings me to another question. And this is what I looked up. What authority will the NDOT have to issue a speeding ticket, or in this case, a minimum speed ticket? When I get a speeding ticket and I go to court for it, the radar detector has to be checked. It has to be a certified police officer. So what are the rules and regulations that says, hey, Grant was going 19.8 miles per hour on a day? Am I being held up because there was a horse carriage or a taxi that broke down? I don't know. But there's too many unknown variables to say, well, if they don't meet the criteria or the methodology. I keep hearing methodology. It's just code word for we don't know. And we're going to figure it out after we pass the rule. And I've been down that road, and it doesn't work. Pay to play. Any junior attorney will get this, take it to court, it'll be thrown out. I'm just going to let you know right now, I don't hold the answers to this, but demanding that we have to pay $30,000 for 38 studies conducted 4 times because someone clocked us on their phone behind it going 19 miles an hour, that opens up the door not just for my company or anyone, but these guys too. Remember, you're going to get into big corporate money that has big corporate ties. I just don't see the point in doing the study. Also, and I'll kind of add to this too, and I've got 2 more points. The NDOT director said if we go below 20 and we lose a permit, like I lose a permit, something that has taken years to get, you build up to, and because I went 19.7 miles per hour.
I think there was clarification that if there was multiple disciplinary
issues about
okay,
I just want to make clear.
Hold on, let me finish.
Yeah.
That they would come before us for a variety of different disciplinary sanctions, not just losing a permit.
Yeah. So that was my concern, because I don't see how you lose. I don't know anyone who can lose a permit off stuff like that too. And to Michael's point, You know, it's the story of the tortoise versus the hare. You know, the tortoise, it goes slow. The hare's running, it's speeding up, it's taking a nap, speeding up. The tortoise wins. And the moral of the story is if we're doing these 13 hop-on, hop-off stops, and I'll give a great example. In front of Chewy's, it's a 2-lane road, one way going this way and a turn lane, in another lane. It's in Midtown, a very high-traffic thoroughfare. If I'm having a vehicle pull over, take 2 minutes, 3 minutes, I don't know, for someone in the very back, maybe they're elderly, to come to the front, get off the bus, and then go, well, that light is green. What traffic study can I not purchase for 20, 30 that will say, hey, look, like, they're blocking traffic and they're definitely not keeping up with the flow of traffic. In fact, they're stopping traffic. I think we're just opening up the door for litigation and a lot more work where eventually these rules get just thrown out or it's just to the point of absurdity. And again, if we're, you know, to Mr. Hayes' point, if we're judging things on acceleration, well then the acceleration to stop at a hop on, hop off, and then the de-acceleration, and then the acceleration to go back up. Well, isn't that worse than just a continual flow of traffic movement? So it's like, I don't know. I had to write all these things down as they came to me right now, but it's like, I'm not understanding how a study is going to change anything, and then in fact, how you're going to prove certain, you know, like, there's too many variables to be like, well, this happened and this was a block and I can't, like, it's either just make it all available for 4 to 6 or make none available. Let's just keep it super simple. Let's keep y'all out of being lawyers and judges. Just do what we need to do. Let's fix the lights downtown. Let's make sure that we're all obeying the rules of the road and just let people just run their businesses without overcomplicating it and making it so legal that everything gets thrown out and we have to start over from scratch. And we've made a lot of good progress this far, but this makes no sense to me. And if anyone can sit down for 4 minutes and go, yeah, this is way overcomplicated, which I think 99% of the people in the room are thinking, what are we doing? Just, it's either good for all or none at all. Just make it easy. Let's not overcomplicate this thing. And so anyways, that is my points.
All right, so Mr. Rosenblatt, Mr. Winters, on our agenda today is consideration of the amendment, which is additional language to Rule 805 that's in the red up there on the board. I understand that you both would oppose that amendment then. I mean, that's just all I heard is criticism about it, right?
I have heard, yes. I'm opposing it because I don't know enough to know what
That's all. I just needed a yes
I don't
or no.
know. What am I spending? What are the criteria?
I'm going back to what the commissioner asked earlier. It sounds like you both oppose it.
If you told me there was a golf cart study like the one we did in 2018, it said, you're doing 20, you're good to go, the whole industry's free. I'd be all for it.
My question simply was, do you oppose or are you opposing the section that's in red up there that's on our agenda today? Not going beyond the agenda, just what's on the agenda.
I'm opposing carving out certain people that can either pay to play or qualify under certain circumstances. I think you need to look at it like the golf cart world.
I think your answer.
Manufacturer says you do 20.
So that's a yes. Thank you. Okay, gentlemen. I just want to get your position on the record here today.
Just don't know enough to make a rule today.
Okay. That sounds like a yes.
It doesn't help.
Thank you. All right, before we close the public hearing, one last chance for anybody. Ms. Alarcon, you have anything else to add? Mr. Carr's already criticizing my opening. No. Mr. Sheffley? Director Rooker?
No, sir.
Well, I am going to ask Metro Legal over there. Ms. Ramsey, Ms. Haber, anything we ought to be considering from your perspective of the legal? There's been several things mentioned about the legal aspects of this particular amendment. Anything you might help guide us today?
No. I mean,
okay.
Really, we have no concerns about this, everybody, because it's available to all operators. Everybody's being treated equally across the board.
And the issue about pay-for-play allegations?
I don't see any evidence of that in the rule.
Okay. Any concerns that are raised in the letter from the law firm Sims and Funk about being vague, about the amendment being vague, arbitrary, or subject to multiple interpretations? And I'm not trying to pin you down, just if you had some thoughts, and if you if you need more time or something, let me know.
None at this time.
Okay, that's a fair. I always love those answers. I love them on cross-examination. All right, I'm going to close. Anybody else at all? All right, I'm going to close the public hearing now. And I'm going to allow us to, or I'm going to ask if it's okay if we can take about a 10-minute break, and that folks can review this letter, and we'll get back here and start deliberating. Is that okay?
Yeah.
Okay.
So a letter from Mr. Magdalene kind of statement.
Yeah, both letters there. Yeah, I got to stand up. Have all the commissioners received the letters that Mr. Reed passed out on behalf of Old Town Trolley?
Yes.
Yes.
All right. Do you want to summarize these for us real quickly? I'll just open the public hearing just for that purpose, or?
I don't think so, unless you. Right.
Very, very strong letters from, you know, Fifth and Broadway, from the district, from Marathon. I mean, great farmers market. Yeah, there's a lot of support from.
What are they saying?
They say that they appreciate the service that Old Town Trolley provides to bring tourists to their establishment, and they hope that we, as the TLC, would consider allowing them to operate to bring patrons to their businesses during these peak times.
Thank you, Commissioner Hayes. Thank you. All right, the public hearing has been closed, and now we're up for discussion and deliberations about what's on the agenda today, which is to add another paragraph to section 805, subsection F. I see heads nodding, so I assume I got that correct. And just, I guess what we can either approve it, disapprove it, defer it for further deliberation or consideration, or if any commissioner wants more information on something, that's another reason for deferring it. I'm not encouraging that necessarily, but I'm just saying I want the options to be available to everybody, so everybody's aware of what our options are today.
Chairman?
Yes, sir.
I intend to make a motion to defer it, so you want me to do it now or wait?
Let's have some deliberation first, okay?
If you insist.
That may start the deliberation, so, listen, it's open. Come on,
There's
folks,
some
let's
information
hear
I'd like
some.
to have.
All right.
I'd like to know what the projected average cost for said study is, surveys. I'd like to know if there are a certain number of companies that provide that service, and if we could agree on which ones those are, or at least be informed. And then there's one other thing, what the methodology might entail.
The methodology that NDOT would like brought to the table by the companies.
Correct.
All right.
I've heard several questions about that.
All right. And Commissioner, who do you want to provide that information regarding the cost of the traffic study and the other matters that you brought up, other than the methodology?
Whoever has it. I don't know. I don't know the source of that information.
I actually have a suggestion.
Okay.
I'm mostly concerned with who would be approved to work with these companies, you know, who is an approved engineering firm, and if there are none currently, what the standards would be to become a approved firm or engineer. And perhaps if somebody is being added to that list, they can provide an estimate from each of them saying this is what we would charge to meet these requirements. I think that serves a two-pronged purpose. It would set not only who is going to be able to make the decisions on these traffic studies, but what the methodology it would be, and then ultimately what the cost to have that methodology evaluated would provide.
I'd like to go a step further and put a limit on how many that you could put on them. 2, 3, 1 every 3 years, 2 every 5 years.
I'd agree with that.
In that, you know, we could find an approved company, but if it's $20,000 a pop for each approved company, and they can do it up to 5 times, I think there should be if. This is an if. One of my favorite things to watch on TV is a program called What If. This is what if this happens. There should be, I mean, there is a monetary value on what we're proposing here, and it's not a small monetary. It's not a $500 fee. As it was brought before us, and I can neither confirm nor deny that they're going to cost $20,000 or $30,000. We might be able to get in, as the state, say that we're putting this out here because it's part of something they have to qualify for, and any engineering firm that qualifies for it has to do it at set price. I apply for contracts like that all the time. It says, okay, this is out here, it's up for grabs, and if you want it, it can't be over this dollar amount. It has to come within this regulation. And I'm sure there are plenty of engineering companies that would apply to say, if we qualify, we can do this for X dollar amount. But they should also, if it comes into play, they should not be just hit with, okay, do it again. Okay, do it again. Okay, do it again.
If I may, Mr. Chair.
Yes.
Thank you.
Sorry.
We would not provide them with a list of qualified engineers. That's not what we do. We would, and there are a ton of, engineering firms out there. I'm more than happy to supply them with the current engineering firms that we have under contract, but by no means am I going to say that's the ones they have to use. We do want to make sure that that's why it's so important the methodology happens, and that when we meet, the intent of the methodology is we go through everything. There's always a structure to a methodology meeting. It's not just hit and miss. And as I said, we currently do this for all our multimodal traffic analysis that we do for today, and we actually have that defined. It's the same practice we would do here, and that methodology, and the reason why it's opened a little bit is because their operation is really also what's going to drive the methodology. How I practice something is not necessarily how the next person practices. I have a management style, TD has a different management style, you have a different management style. That kind of has to play into the methodology. We go through, we will have some criteria that everyone's going to follow, but their operations may require that we think a little bit different, and that then gets written down and documented, and when we walk away from that meeting, we all agree that this is what they will do. We're agreeing, they're agreeing. If they follow that methodology and come back and provide us with the data based on that methodology, they're done. They wouldn't have to do another study. But if they bring me back a study that didn't follow the methodology, we would not accept it. So then they would have the choice to go back and do it based on the methodology that was agreed upon by all parties, or they'll get denied.
Director, may I ask, so I can appreciate what you're saying there, and I can appreciate you not wanting to be in the business of determining which engineering firms qualify. But however, by the plain language of what's been written up there, NDOT has to approve the engineer or the engineering firm. So at some point, NDOT will have to make a call as to whether this engineering firm is acceptable or not. And it's not that I don't necessarily support that you can get out of that by simply deleting that provision, but there has to be some standard. We can't say that NDOT can approve or disapprove engineers without having some type of standard that we're doing that by.
So actually, the document says that must first obtain a traffic study performed by an engineer who is licensed in the state of Tennessee with experience on performing such studies. So that's all. We don't have to approve it. The engineer or engineering firm and the methodology to be used in the traffic study must be pre-approved by the NDOT's chief engineer. So when we sit down and do the meetings, the chief engineer is involved in these meetings. And so it's everybody sitting at the table having the conversation. So if they bring someone who's a structural engineer and has no practice whatsoever in traffic, you're going to say they're going to struggle. First of all, I can't imagine a structural engineering taking on a job that's involving traffic, because it is two different worlds in the engineering world. But we're just saying it has to be someone who has that experience or that knowledge, and they would be able to understand that when we're defining a methodology and we're saying you're doing ABC, they understand what ABC is at.
Absolutely. And Director, I would imagine that one of the elements of the methodology would be to use an engineer trained in these practices, right? So it sounds like it's a bit belt and suspenders there. I'm just saying that I think that there creates some type of ambiguity there, saying that there is both NDOT's chief engineer both has to approve the methodology, which makes complete sense, and I understand you have written down and that can be accessed, but as to who is implementing that methodology on behalf of the person applying under this rule, I think that there is some ambiguity there as I read it. That's all I'm saying.
So again, we're just looking for someone who is licensed in the state of Tennessee and represents some experience. And, you know, I'm more than welcome to share our information of who we currently have on file for them to use. They have the ability to negotiate with every single one of these firms, just like we do. You know, so it's hard. I would think that when we do our studies, our traffic studies, we're probably paying a lot more than they ever will. I would not recommend they use our pricing. But I would say they're more than welcome to use our engineers. That's a public document. It's on the webpage, every single one there, and we're even willing to print it out and provide it to them. But if they bring us someone who's not one of our engineers and they are a licensed Tennessee engineer, they're licensed in the state of Tennessee, and they do have the experience, we're not going to say no. But we are going to sit down and have that conversation on the methodology of what they will be studying and what needs to be provided in that study when it comes back for consideration. And every one of us will agree on it, that this is the study. We're walking away from this with a clear understanding of what it is, because we don't want to do it twice either, and we don't want them to have to do it twice. That's why that methodology is spelled out so well in this particular rule, is you will meet, because we don't want someone to go and do a study and then bring it to us and say, here's my study. And we're like, well, wait a minute, you didn't do the methodology, we're not going to accept it. That's the reason why that is spelled out here, is because we want to have that conversation. We want to meet with them. We do have rules and standards that we follow. As I said, it's part of our current practice today. It's very important. That's why it's kind of spelled out this way, but it gives them free will. They're more than welcome to use our engineering firms, or they can use their own license in the state of Tennessee and experience.
Well, humor me, if you will. Is the methodology already guidelined out?
As it's part of our multimodal transit and
Right, but-
traffic analysis, it is kind of lined out. But as I said, operation has to play into this. And just like in currently the methodology that we use when we're doing a traffic analysis and sitting down and going through that with a developer coming in, how they develop their building will also play into that methodology. Their operations will play into that methodology. So that's why.
But we already know their operations, and we.
But it does vary from company to company. You can't say they all perform the same way, because they do not. One has a tractor, the other one has a bus, the other one uses actually something else. You know, so that plays a big role in the overarching conversation.
Understand, but I think I would feel more comfortable, because the methodology in this kind of is like that word perfume in when you're looking at ingredients. It could be a lot of stuff in there that we don't know, that as a board I might not approve of. And I guess I would just feel more comfortable with, I don't know, a basic guideline that says it's going to be, and I know that they're going to differ some, but I can't see that there can't be a basic with a subsection if. You know, A, B, C, D, and subsection A if, and subsection B if, so that we could see what they're going to be held to, and what it might cost them, and what timeline that might be.
We can certainly get that to y'all.
Go ahead. It's on.
Well, I tend to agree with the party bus fellows over there that this is overly complicated in my book. I think that that we've got a situation where you've got they don't care for Old Town Trolley's operations. Old Town Trolley does not consider themselves part of this group, but yet they're lumped in together here for regulation. And I think it might be maybe more appropriate for the council to consider whether they want to treat these industries different than for us to have this elaborate study process. And I know that doesn't come at an easy lift for you all, but that's where I am on this. That I tend to not agree with going this route and putting all this discretion within NDOT to do all this.
Oh, we would.
I don't think we have the discretion
Yeah.
to treat.
No, that's what I'm saying.
on a
They need to.
regulatory basis.
That's what I'm a no on this. I'm going to be a no on this because I think it's overly complicated, And and I know we're not taking maybe a vote today, but I'm just explaining that I think that they should not be regulated necessarily the same. And if they are going to be, I'm not on board with this approach. So I'm just being transparent and yeah. So
I agree that it is complicated, and it seems very overly complicated, and I think that's why it's where it is, and not necessarily where it should be. And I don't think it's gonna go away without us dealing with it. And as complicated as it might sound, and as much as I wouldn't want to deal with it, it's down here with us for a reason. And so, I mean, we can run from it all day. It's gonna be here, and it's not gonna help them for us to just continuously defer it, and they keep showing up here, and it becomes soup.
I'm not actually against the concept of it. I think I agree with you that these are two different industries that have unfortunately been lumped together. But I am very much wanting it to be something that is fair for everybody. And I think that there is just a lot of questions remaining unanswered about that. So I don't want to say that I'm necessarily inclined to vote either way at this point. I do support at least a short deferral to where we can possibly get some of these questions answered. But that is my overarching concern.
Commissioner Westlake, Commissioner Hayes, you have anything you want to add? I would say one thing, though. If there was a vote of turning it down, I think what you were speaking to is that
be status quo.
they could go to the
Yeah.
council and lobby and ask for separating them out, and then we would be saddled with new regulations for what might be deemed sightseeing vehicles.
Right.
So,
And then we wouldn't have the question of whether they can convert from one to the other and back and forth and those sort of things.
Or if staff feels really passionate about this amendment, you've probably heard a lot of commentary today from the commissioners with concerns on methodology, concerns on, I didn't bring it up, but concerns on routes. I've certainly spoken to Old Town Trolley folks on my concerns before about being on a single lane street, which they're on a lot of them. But putting in the slow moving vehicle that stops at a peak time on a one-way street that's one lane is a challenge. And I think your traffic study was really clear that that's not a good idea to put any extra slow moving vehicle doesn't need to be there. So I can't say that I support this the way it's written. Maybe if this was written in a different way that had a clear methodology for each type of vehicle so that we can look at it instead of relegating it back to staff in some dark room. I don't want to say some dark room. But your conference room has no windows.
Let's strike that one comment.
Your conference room has no windows, right? But and your offices, they should be upgraded. They're tired. They are. It's a block building. But seriously, if there was tighter language, I might be able to be for it. But I think that just having a methodology that I don't know what it is, I can get my head around the traffic study, but I certainly would want it to add starts and stops, not just maintaining the speed of traffic. This could be better worded to get me on board.
So I agree that there's some lack of clarity, but I also have the sense that a regulation doesn't include the granular kinds of things around methodology that would be required, because then you have to come back. I mean, you made a little error, you have to come back and do it. I mean, from my experience in reg writing. But certainly finding out about what the multimodal methodologies look like. I mean, having a sense of what the policy is. And so understanding what we're voting for in that regard makes sense to me. Trying to put all of that into a regulation or a rule doesn't make sense to me, because
they're I guess, relative to staff, they're if you had a pre-baked methodology for a hop-on, hop-off tour bus, a converted school bus, a really fancy really fancy VIP bus, a tractor trailer, you know, or what is it, you've got a trailer behind a bulldozer, right? Like, there's probably 4, 5, 6 types of vehicles that you could write a methodology for.
Fire truck.
A fire truck, yeah, 6.
That may not necessarily need to be reflected in the language, but it could be a policy document.
That at least we would have,
with it, so
we would
know.
know.
Yeah, 'cause right
and
now, we don't
there's a
know the
lot less
methodology.
subjectivity.
Yeah, exactly. I don't know what that evaluation looks like. I don't know how much it costs. I don't know how that's going to impact these businesses, and I'd be reluctant to make a decision so quickly that could have far-reaching effects.
Well, given the moment of silence, Commissioner, did you have a motion?
Well, it sounds now like y'all want to vote against it, so if we're going to do that, let's just do it.
Throw something on the table so we can get started.
I vote we disapprove the proposed rule change.
Wait, is that a motion or a vote?
It's a motion. Do we have to have a motion?
We do.
Yeah.
Yes. We start with motions.
Well, I guess I could make a motion to approve it, but then I'm going to vote against it. So
I'll move that we defer, or that we, decline language amendment to section 805F safety that's been proposed by NDOT in the red on the screen.
I'll second that.
All right, and just so I understand the motion for everybody here, that is a motion to decline the language in 805F as written.
In red.
In red, in
Yeah,
the
not
amendment.
red.
Color
Right.
blind,
Yeah,
so,
okay.
but yes, the amended motion.
For the amendment to section 805 subsection F.
Yes, sir.
And the motion is to decline the language.
Yes, sir.
All right, not necessarily to decline the concept or something necessarily.
We don't want to do away with 805F.
No.
No, correct.
With just the amendment to it.
All right.
The proposed.
All right, there's been a motion and a second. Any further discussion? All in favor say aye.
Aye.
Any opposed?
No.
All right. Did you get the record correct on that? Okay.
5.
So, the agenda item is that the amendment, the section that's highlighted in red, as proposed by NDOT for a rule change in section 805 subsection F has been voted down.
Question. Would there be an appetite to propose a motion that involves answering some of the questions for further reconsideration?
Well, I mean, we've already voted on it now.
You can ask,
I know
I think
that,
you
so
can ask
it's-
staff to do that, though.
I would say
It's
you
done
wanna
now.
ask to have it, perhaps maybe have something put on the agenda during a meeting that's not real busy for answers to those questions, which I think the March meeting's not terribly busy.
Okay.
Does not shaping up to be too bad.
Doesn't look too bad
So
right
far.
now, so far.
Okay.
All right, so why don't you go ahead and articulate what you're looking
To put on the menu, is this a motion?
for?
that I-
Agenda.
No,
Well,
to
no, you don't have to
request
have
the
a
staff.
Okay,
motion.
I said
Just-
menu.
just ask to put on the
You're just
agenda.
requesting.
I'm just requesting that we include on the March agenda, if there's room, information regarding the areas of questions and concerns that we had that might give us more insight on whether or not we want to raise this issue again.
And if I could just recap the questions, just to make sure that I recorded them all correctly. I have the first one, average cost of study. The second one, number of companies that do the studies. Number 3, the methodology guide that we would use, and that was mentioned, so we'd bring that forward. If we have any approved engineering firms, but I think I addressed that we don't do that, so I wouldn't bring that forward. And then also, in the methodology, we would treat that as not necessarily in the regulations, but as a footnote, I guess. I don't know quite what the terminology, but y'all would like to see that, and also including that tighter language about stop, start, and that kind of stuff in one-lane streets. Did I cover it pretty well?
I remain also really curious, because of Mr. Winter's commentary remembering the meeting from a year ago, how the Nashville trolley stops at WeGo stops, how that came to be.
Which is really outside of
It is,
this
but
regulation.
it's outside,
Yeah.
but it's happening, I think.
I think it would be appropriate for
It's an
Mr.
appropriate
Winters to
question
file
for
a
the-
complaint with the director.
I'm,
Yeah.
can I not ask that question?
Yeah, yeah.
Yeah, I'm
I
asking the
think-
question. I'm just curious.
We will follow up on that.
Yeah.
I mean, we haven't received that complaint from Mr. Winters, so we'll take that information that we heard today. Ricky will do a full investigation. We'll bring that back to y'all in March. Is that okay, sir?
Oh, absolutely.
Perfect.
And if, there's a lot that we're asking, and so if March is,
deliver.
I'm okay for like November, personally.
We can deliver.
All right, you've got a lot going on.
Yes, we do. We can deliver.
Mr. Reed, since you seem to have been the proponent of the amendment to section 805 subsection F, if you can provide us any information in March about what it costs for traffic studies and things of that, anything that might be helpful in answering some of these questions, that would be helpful.
Yes, sir.
All right, thank you. And I do want to thank Mr. Reed, Ms. Barker, Mr. Winters, and Mr. Rosenblatt. I appreciate your time today and the input you gave us. I know, I could tell it was passionate from all of you. And I know there's financial consideration. We all know, everybody up here knows there's financial considerations in this, and I thank you for your time and your input. Sure, one question.
I really don't want to file a complaint on Old Time Trolley.
Well, you're not.
I would like this board to figure out how to resolve.
I think that,
right away without me filing a complaint.
relax. I think Mr. Hayes has put it on the agenda with his inquiry. So, you're welcome. All right, next, does that conclude that business as far as anybody can tell?
Yes, sir. Oh.
For what?
Well, he said it was
No,
a
he just
request.
requested from
Just
staff.
request for it, Yeah. Okay, moving on to other business. Mr. Rooker, any other business?
There is no other business, Mr. Chair. We do need to do the application reviews, of which you would need to read your statement.
Let me see if there's any commissioners that have any other business they want to bring up. Okay, Mr. Rogers.
I would like to propose that I'd like to propose that we pass a rule that requires us or the staff to publish any proposed rule changes 2 weeks in advance of a meeting. We heard some issues about that today, and the fact is, the law that covers SUMDs has that requirement in it, because somebody who wrote the law put it in there. So I think that would be good practice for every time we propose a rules change.
So add a week?
Add a week, basically, 2 weeks in advance of the meeting.
I'd get behind that. That's fair enough. Would that cause any concern for your office to add a week to? Well, if you throw it out there, I'll. Oh, you gotta, never mind, public hearing.
We don't have a public hearing to change a rule.
Right, change the rules.
But I think we're checking to see if that's in the code.
I think that the SUMD rule change that he's talking about is in the code. So if you wanted to, that's a council job to amend the code.
No, I think we could make it's a rule about our procedure, and we can make rules about how we proceed and things, can't we?
I believe you could if you want to make it to mirror the SUMDs. Do you want it to be in the code, or would you rather
Oh, no,
it be?
I don't care, as long as we make our own rule to do the same thing. It's a lot easier than getting them to do something. So I'd propose at the next meeting, we consider a rule to do that.
So at the next meeting, we would propose a rule change which is going to require a public hearing, which is going to require the proper notice.
2 weeks.
Yeah.
2 weeks.
We can do that.
Same language.
Yes, sir. Okay.
And publish it 2 weeks in advance.
All right. Any other business?
There is no other business other than the application reviews, and we'll need to,
Close it.
read your statement.
You know, I don't have my statement for that.
I'll propose that any meeting that goes over 27 hours, that NDOT provide food.
Plan on having food here for people.
There we go.
We literally, I think we
All right.
go 7-hour meetings without a break.
We will now close the meeting to the public hearing. And I am going to give notice that the broadcast section of this meeting has concluded. The remaining portions of the meeting will not be broadcast because the commission will be considering confidential and protected criminal history background information of driver applicants. Questions should be directed to the Transportation Licensing Commission office at 615-862-6777 if you have any questions about why we're closing this meeting. Are we off?